Wait, my lord. Day before yesterday, I had mentioned an item, my lord, to be listed today. That has been listed, my lord. It is urgent, and
Correct.
another item,
Okay.
which was also mentioned, has come today. That is item number 33 in the supplementary list. Both are have to be taken up together. Item 33 in today's supplementary list.
Yes. So
So, my lord, let this item come with two, my lord, both.
this with which matter?
My lord,
Which matter? 33 with any other item.
this, my lord. This,
What is that?
filing number 14923. It was mentioned day before yesterday.
It is newly filed. Already filed.
Filed on last Saturday.
Okay.
With two, my lord. Both
Okay.
items.
May it please, Your Lordship. Your Lordship, with the consent of the petitioner, I beg to mention item number 21, Your Lordship. In this matter, I am appearing for the private respondent number 4. We need 2 weeks' time to file our affidavit in opposition, Your Lordship.
Yes, wait for 2 weeks time is granted.
Appear for the petitioner here. Lordship, the government.
Consent is not
I
there.
have concern. I have
Then?
no problems.
Then
Lordship, the government may be directed to on the next to produce the relevant records.
who's
They
for the
file
government?
affidavit, but the records will be necessary
Alright.
for disposal.
As straight for 2 weeks time is granted to the respondent number 4 for filing affidavit in opposition.
21.
21.
List the matter again. When?
In the month of January after the revocation.
In the month of January. List again in the month of January 2025. State Council shall produce the departmental records on the next date. All right.
Obliged.
May I please,
Now the thing is that, my lord, this is what my friend is submitting.
No, you have filed the affidavit, the relevant records pertaining to the roster, etc. That is what, whatever you have, you produce. If you don't have anything, don't. That's it.
Yes.
To the Lordship. Lordship, in item number 38, we have filed an affidavit in opposition. That may kindly be called for.
Yes. All right.
May I please, Your Lordship, I beg to mention for listing, so matter may become up 13th of December.
What matter is that?
Motion matter, my lord.
Motion matter.
Motion matter.
What is the urgency?
Urgency is the issuance of license of
Huh?
for wine shop, my lord.
Bench 3.
Hence,
Bench 3.
Take it up on Monday. Next week will be motion week.
oblige, my lord.
May I please, Lord?
Yes.
Lordship, I beg to mention the writ petition for listing, Lordship. It's old matter, Lordship, on day after tomorrow, kindly.
No, why? What is the urgency?
Lordship, the person is, demoted and his salary has been held up since last 6 months, Lordship. So some urgency is there, Lordship. The person has been suffering, Lordship. He is not able to manage his medicine and all, Lordship. Day after tomorrow, Lordship.
No, we'll have it next week. Not day after tomorrow. We'll have it on Tuesday.
Lordship?
Tuesday next.
Obliged.
17.
May it please, Your Lordship. Your Lordship, I would like to mention a matter for listing. I am for the petitioner in this case. Here in this writ petition, I had filed a writ petition for recasting of the seniority list, wherein the petitioners were placed lower than the respondents. In the meantime, during the pendency of the writ petition, there was an interim stay of any promotion to the next higher post. Now that particular seniority list has been recasted by the department itself, and now I've been given higher standing in that seniority list. As such, because of the stay order, Your Lordship, now I'm not being able to get promoted because it was a blanket stay not to promote anybody. Because of that particular stay order, the respondents are now finding it difficult to promote the petitioners now.
You are the petitioner.
I am for the petitioners.
So you withdraw the writ petition then.
Your Lordship,
If the relief has been given.
relief has been granted, Your
Then?
Lordship. That's why I prayed for the listing on Friday, Your Lordship.
All right.
Highly obliged.
May I please, Your Lordship.
Yes.
With the consent of the other side, I need some accommodation in item number 27.
Yes.
The learned counsel for the petitioner is in bereavement. And the matter may be taken up after vacation.
Counsel for the petitioner, Mr.
PJ Bora.
PJ Bora. He said to be in bereavement. On a mention made on his behalf, matter stands adjourned to be listed again after the winter vacation. All right.
May I please, Your
Obliged.
Lordship?
Yes.
Lordship, with the consent of the petition, I beg to mention item number 3 and 4, Lordship.
Lordship, can this matter be taken up on 7th of January, Lordship?
Why?
Lordship, because this week there is some difficulty, Lordship, immediately after vacation, Lordship.
There must be a reason for,
Lordship, we have received our instructions. In the meantime, we will file our affidavit as well, Lordship.
you've taken consent.
Yes, Lordship.
Mr. Deepamanya, Lanet, Standing Council Health
Health, yes, Lordship.
submits that. Have you filed the affidavit?
No, Lordship, we have just received the instructions, Lordship.
Submits that he has received the instructions. And maybe given 3 weeks' time to file the affidavit in opposition. To stop, he submits that he has taken the consent of the other side.
Lordship, he is
Lordship,
here.
I am for the petitioner, Lordship. There is an interim, Lordship, that should be accepted.
In view of above, list the matter again after the winter vacation. Interim order passed earlier to continue till the next date of listing.
Lordship, can a date be fixed, Lordship? 7/1/25, Lordship.
Winter vacation. After that, you just put 7/1/2025
Highly obliged, Lordship.
on the mail, on 7/1.
May I plead your lordship? I beg to mention item 23 of today's list, your lordship. I have taken the consent of other side, your lordship. The engaged council has some difficulties today, your lordship. Can the matter be on 19th, your lordship?
Finding it difficult, my lord. Let it come after petition, my lord.
Then, your lordship, a date may be fixed, your lordship. The petitioner is going to retire, your lordship, so if an early date is possible,
When is he going to retire?
on February, your lordship.
Okay, list on 10th of January 2025 as paid for.
Oblique.
Lordship, I beg to mention for listing a motion matter, Lordship. Friday, Lordship, it is urgent, Lordship.
He'll come on Monday.
He was terminated from service, Lordship. If there is a criminal case pending, in that
Monday.
case, he was appointed, Lordship, maybe on Friday, Lordship.
Monday.
Lordship, Monday is some problem. I will not be available.
Tuesday then?
I leave. That's why.
No, what to do then?
Maybe on
Next
Friday.
week will be a motion day, motion week. So you take it up on that any date. Any date you want, Monday, Tuesday, Wednesday, Thursday, Friday.
Lordship, next week I.
Not this week. Next
not
week.
entirely
This is a termination from service. There's no urgency, Mr. Counsel. Monday. Yes,
Wait, Mr. Lordship, I beg to mention for listing of two writ petitions, Lordship, for motion. The matter was last listed on 07/11/2024, and similar matters relating to appointment of Grama Pradhan has also been listed on Monday. Lordship may kindly take a.
Monday, okay.
Pleasure, Lordship.
May I please, Lordship?
Hmm.
Lordship, clear for listing. In this case, Lordship, listed after 2 weeks, Lordship, 2 weeks over, Lordship. So Monday, Lordship.
What matter is that? Listing for what?
Lordship.
Orders, admission, hearing, motion, admission. You have it after the vacation. We'll give you a date. The next week, there'll be too many motion matters. Your matter will not reach. We'll list it on reopening.
Lordship, before vacation, any date.
Why before vacation? What is the urgency?
Urgency, Lordship, selection and appointment, rehabilitation of worker, Lordship. Before vacation, any date, Lordship.
You have it on Wednesday then. On 18th. 18th. Yes.
It's similar for listing of this matter for admission because the person's promotion has been held up, not approval by the chief engineer.
Urgency is there.
Lordship, some person is going to be retired by next year, Lordship. That is all.
By next year.
25. 25.
Next year when?
March.
March. So you can wait for some time, I think. We'll list it on immediately on opening.
A date may be
You have it on 8th of January,
8th of January.
2025.
May I please, Lordship. Lordship, I beg to mention item number 17. Kindly pass over for the date.
17.
17.
You're for
Opposite
the
party
petitioner.
concern. Yes, Lordship.
As paid for by the council for the petitioner, matter stands passed over for the day. Yes.
May I please your lordship, with the consent of the other side, I beg to mention 19 and 20 of the daily list, my lord. My lord, I am praying on behalf of A Bora, my lord, standing council NHM, my lord, on.
Yes, why do you want adjournment?
Yes, my lord.
But I am for the petitioners, my lord, in both the cases.
Sorry?
I am for the petitioners, my.
Okay, I'm asking him, why does he want adjournment?
She's out of station, my lord. She is some
A.
personal
Bora.
difficulty. Yeah, A Bora.
A. Bora.
Yes, my lord, NHM.
So when do we list it then?
Immediately after vacation.
Learned Standing Council. A.
NHM.
Bora.
A Bora, NHM. Standing Council,
A.
NHM.
Bora.
A Bora.
Standing Council NHM.
Yes.
Mr. A. Bora is said to be out of station on a prayer made on his behalf. Her or his?
Oh, he's her.
On her behalf and not objected to by the other side. List the matter again after the ensuing interpretation. 19 and 20.
Interim is there, my lord, in both the
Both are
cases.
past earlier and continue till the next date of listing.
Obliged, my lord.
Much open.
Wait, please, your lordship, I
Yes.
beg to mention for listing, your lordship. Lordship, it is a pension matter and my pension has been stopped and I'm having extreme hardship, your lordship. So may the matter be listed on Monday, your lordship.
Wednesday,
When,
18th.
like, your lordship.
I beg to mention my item number 71, my lord.
71.
71, my lord.
There is no item 71 today, I think.
My lord, there is a major clerical mistake, my lord, in the petition, my lord. Maybe allowed to withdraw the petition.
There are only
with the,
40 items today. Where is 71?
21 meter nine.
71. I think you're in the wrong port.
Supplementary. There is supplementary. My case is listed on item number 71, my lord. Today's list.
Mr. Counsel, there is only 40 matters. There is no question of 71 item. Yes.
May please, your lordship, I beg to mention item number 16, lordship. Kindly matter may be adjourned for 2 weeks, lordship.
You're for the petitioner.
I'm for the petition.
Why do you want adjournment?
Lordship.
Why do you want adjournment?
Small affidavit we will file reply, lordship.
Okay, 2 weeks time is granted to the petitioner for filing reply affidavit as prayed for. List again after 2 weeks. Yes.
Obliged, lordship.
mention item, I beg to mention, my lord, one read petition, my lord, fresh motion matter, my lord, regarding pension, my lord. The matter was listed, my lord, on 9th, my lord, on Monday, my lord, wrongly, my lord, in civil bench, 2 bench, my lord. So maybe taken day after tomorrow, my lord, urgent pension matter, my lord.
What
Fresh
is the
motion-
urgency?
Pension matter. So, my lord,
You can wait,
petitioner,
you
family
can wait.
pension, the petitioner is more than 70 years old.
We'll have it on Tuesday. Tuesday.
My lord, wrongly listed Monday. That is why, my lord, I am praying on Friday only, my lord. Friday.
17th, okay? On 17th.
My lord, 17th. My lord, another pension matter, maybe in the next week also, my lord. Both
Okay,
the
there also
pension-
17. Yes.
Already did 21/8/2023.
Page number?
11, page 11. That has not been complied.
Okay, what is the direction?
It's direction at page lordship 14.
Provisional pension.
Yes, lordship, post retirement, they had corrected they have affected change in the date of birth of the petitioner, with effect from a date prior to, at least 5 years prior to his retirement. And that was set aside by the honorable court, and there was a direction for releasing his pensionary benefits.
Okay, heard Ms. D. Borgohain, learned counsel for the petitioner, who submits that the order dated 21/8/2023, passed by this court in WPC number 3825 of 2020, has not been complied with, despite a copy of the same having been furnished. To the respondents. Next para, issue notice, returnable by 4 weeks. Petitioner to take steps within 3 days for service of notice upon the respondents. Yes.
My lord, this is the branch 4 matter.
List the matter before the appropriate bench. Bracket bench 4.
Lordship, next week, Lordship. Maybe mention.
You make a prayer before the registry. Yes.
The matter relates to appointment or compassionate judgment.
Hmm.
The improved rejection is at page number, my lord. Relevant portion is at page number 41, my lord. Point number 12, my lord.
Page number?
Page number 41. 12, my lord.
below. District Information and Public Relation Officer, Sonitpur District.
Yes.
The District Information and Public Relation Officer, Sonitpur District has sponsored one number of post proposal vice, Sri Konkan Jyoti Kolija, son of so and so, for grade 4 post. The district level committee has discussed, examined the proposal as per Gov. OM number so and so dated so and so, and decide to reject the proposal due to time bar. This was done in the year of 2018. Thereafter, again the issue of the petitioner was considered. That is right, page number 46. Page number 46. 7, paragraph 7. District Information and Public Relation Officer, Sonitpur District. The District Information and Public Relation Officer, Sonitpur District, has sponsored one number of proposal vice, Sri Konkan Jyoti Kolija, son of so and so, for grade 4 post. The district level committee has discussed, examined the proposal as per memorandum dated so and so, and decided to uphold the decision taken in the DLC meeting dated the earlier minutes, 2018, which was rejected due to time bar, as the applicant submitted his application in the year of 2010. This was important. This is important. 2010, after 9 years of death of government employee in 2001, which is required to be submitted within 1 year from the date of death of the government employee as per the above original. Now, kindly come to page number 24. Annexure number 2. What happened, my lord? The petitioner's father died on 27/4/2001, my lord. Thereafter, his mother, my lord, submitted application dated 30/5/2001, my lord. That is at page number 24, my lord. Annexure number 2. My lord, this was submitted, but till 2005, my lord, her application was not, my lord, considered. And at the time of filing of this application, my lord, the petitioner was minor. Thereafter, in the year of 2005, my lord, when the petitioner became eligible, my lord, after attaining majority, his mother submitted application, that is at page number 27, my lord. Annexure number 4. In the year of 2005, my lord, it was submitted, my lord, with a request to appoint the petitioner instead of his mother, my lord. And the official communication, my lord, that is at page number 31, my lord. From the official communication, it is, my lord, found that, my lord, in page number 31, my lord, paragraph number 2, my lord. In this connection, it may be mentioned here that Sri Konkan Jyoti Kolija, that is the petitioner, my lord, son of late Farkeshwar Kolija, has been applied for a post of grade 4 on compassionate ground instead of his mother. Parvati Kolija.
From where are you reading?
My lord, it is paragraph, last paragraph number.
Page number?
Page number 31, my lord. This is of 19/6/2006, my lord. And the application referred herein, the application dated 22/11/2005, my lord, submitted by the mother of the petitioner, my lord. From this communication, it is very much clear that the application was submitted not in the year of 2010, my lord. It is much prior to that, my lord, as held by the my lord, as observed by the DLC meeting, my lord. And my lord,
Tell me one thing. Why did the DLC consider your case twice?
My lord, I don't know, my lord. I have no information in this regard, my lord.
You have not come before.
No, my lord. I have not.
This is the first case. This is the first time.
Yes, my lord.
Because on 29/8/18,
Yes, my lord.
DLC considered your case.
Yes, my lord. But
And
no
again,
communication was met, my lord.
Again, on What is the date? 1/7/2022.
Yes, yes, your lordship.
Again, they considered.
Considered, my lord, at the instance of the official communication, my lord, perhaps, my lord. I don't know, my lord.
Yes.
From it is very much
Mr.
clear that
Siddharth?
My lord, to start with, my lord, the petitioner was a minor
Hmm.
when his father died.
Hmm.
The Supreme Court has held that, my lord, and thereafter our court coordinate benches passed many orders, my lord, that a minor is not entitled, my lord, for compulsion appointment. A post cannot be held for him, my lord. There are getting of judgments from our court and Supreme Court, my lord. Supreme Court in Rajuddin, state of Manipur versus Muhammad Rajuddin, my lord, has already, my lord, has held that, and that is the law.
lordship, may I?
He was a, my lord, admittedly, he was a minor.
Yes.
And my lord, if you go by my lord, our OM and this honorable court's order, my lord, in Fadrun Nisa, it has to be, my lord, filed within 1 year. The application has to be filed in a span of 1 year. The petitioner was admittedly a minor. They did not, that is why my time barred means what? The DLC has, my lord, held that it was time barred, meaning thereby the application was not filed within 1 year. He could not have, my lord, only because that he is a minor. A minor cannot file an application, my lord.
Mother had filed. No?
Lordship, in this connection, my lord,
Mother has filed for mother. Father is not before your lordship. Here, son is before your lordship. Mother did not come challenging her appointment, my lord.
my lord, I have annexed Honorable Supreme Court judgment as well as.
My lord, mother
order of
is
this
not before your lordship. The son is here.
No, I know that. Mother is not before. But see, son was a minor. So mother had to apply. Then what happened to the mother's case?
My lord, in this connection, my lord, I have annexed on judgment, my lord, of this honorable court, my lord, at page number. 59.
Mother was not considered.
Yes,
So
sir.
meantime, the son had become major. So he applied.
He cannot.
Why not?
That is what Supreme Court said, my lord.
My
Why
lord,
not?
this position will be clear, my lord. Kindly
My
come
lord
to
will
page number
take this matter
59.
up after 10 minutes. I will place 2 judgments of our High Court and Supreme Court, my lord. In this, it's very clear, my lord.
Okay.
My
Okay.
lord, now, my lord, kindly
You
come
produce
to
the judge.
page number 59, my lord.
What
Page
is
number
there?
59, my lord.
What
of
is
this,
there?
Judgment of this honorable court, my lord. It is held with reference to the honorable Supreme Court judgment, my lord. My lord, in this, my lord, paragraph number 2, my lord. The father of the petitioner who was serving, my lord, at page number 60, paragraph number 2, my lord. The father of the petitioner who was serving as Hindi teacher in the Kahibari the ME school died in harness on 2008. Upon his death, his wife, namely Noor Begum, had submitted an application for compassionate appointment, but as it appears, the same was not given due consideration under law.
When was that?
My
When was the application filed?
that was within time, my lord. And my case was that similar nature, my lord. My mother applied, my lord, within time, my lord. After only 1 month, my lord, of death of my father, my lord. My mother has applied, my lord. This is very much similar, my lord. But that
Departmental will come in, my lord. 21 years is left. 23 years.
let me submit. Be that as it may, the petitioner who was a minor at the time of death of his father had submitted another application on 2017, my lord, for compassionate appointment. That is after, my lord, 11 years, my lord. Sorry, my lord, 9 years for compassionate appointment upon attaining majority. This petition has been referred on the grievance that the said application of the petitioner dated 18/9/2017 had not been considered by the respondent doctor. Now, my lord, after giving 2 paragraphs, my lord, paragraph 5, my lord. It is noticed that at the time of the death of the father, the petitioner was a minor, and therefore he could not have applied for compassionate appointment, my lord. But upon attaining majority, the petitioner has submitted the application dated so and so. The law in this respect has been settled by the Honorable Supreme Court in Syed Khadim Hussain versus so and so, wherein in a similar circumstances, a view was taken that where the application for compassionate appointment of the widow submitted within the prescribed period was rejected without any reason, the subsequent application by a person who was a minor at that relevant point of time has to be considered as per its own merit, and the same cannot be rejected merely on the ground that said application was met after a considerable period of time. Madam. This is my case, madam.
Where is that judgment? 2006-9 SCC 195.
My lord, in the previous, my lord, page number 56, my lord.
Which paragraph?
Paragraph, my lord, from second paragraph, it starts, my lord, what the relevant portion is at page number, paragraph number 4 and 5 would be relevant, madam. We have had the appellant counsel and counsel for the respondent, paragraph number 4, my lord, 57, page number 57. Counsel for the appellant points out that after the death of the government servant, his wife submitted an application and it was rejected without giving any reasons. And the counsel for the estate submits that due that the same must have
Okay,
been
okay.
rejected.
Will issue notice, Mr. Dhar.
And
You
now
take your stand.
another thing was that OM will come in between, my lord. Our 2024.
Yes, yes. Let's see. Your good name? What is your name?
MS Talukdar.
Heard Mr. M.H. Talukdar.
My lord, may I
Honored-
say one thing, my lord? This may be
No, my lord.
for consideration, my lord. I have also submitted another application in 2022, my lord, detailing all this, that my mother submitted application within time. Thereafter, another application for.
Let notice go at this stage. Okay. They want to obtain instructions. Heard Mr. M.H. Talukdar, learned counsel for the petitioner, who submits that the father of the petitioner expired, died in harness on 27/4/2001, and therefore his mother submitted an application on 30/5/2001 for compassionate appointment. Since the petitioner was a minor then, so the application was not considered, and therefore, on attaining majority, the petitioner submitted his application for compassionate appointment on 22/11/2005. Stop. However, why the DLC minutes dated 29/8/2018 and 1/7/2022. The application of the petition has been rejected as time barred. Stop. The learned counsel submits that. The case of the petitioner should be considered in the light of the decision of the apex court in Syed Khadim Hussain versus State of Bihar and others, 2006-9 SCC 195, page 56, which was also relied upon by a coordinate bench of this court. In WPC number 364/2018, open bracket, Safiqul Islam versus State of Assam and others. Next para, in view of above, issue notice of motion returnable by 4 weeks. Mr. Aadhar, Lanet State
My
Council
lord,
accepts.
record my submission, my lord.
Is it required? You file affidavit?
No, my lord, regarding the maintainability, my lord. Because this writ petition is not maintainable. That is what we want to say, my lord.
You accept notice on behalf of which respondents?
1 to all, my lord.
1 to 4.
All, my lord.
Respect, Mr. Aadhar, Lanet State Council accepts notice on behalf of all the respondents. As such, notice is complete. Petitioner to furnish requisite extra copies of the writ petition to Mr. Aadhar within 2 days. Stop, Mr. Aadhar. has raised the maintainability of the writ petition
Lordship, may I prefer one?
in view of the office memorandum issued.
On three grounds, my lord. One is the petitioner was a minor.
Okay, forget it then. Raises the issue of maintainability of writ petition. Stuff as such, the same is left open.
Well,
Hmm.
keep the-
Your Lordship.
Yes.
The petitioner is a peon and is serving for last 24 years. I have communication dated 31/24 and XR 11. The respondent has sought approval from the secretary to start departmental proceedings for termination of service and to refer it to a investigation agency. This XR 11 page 44. Page 44. With reference to the subject cited above, I have the honor to enclose here with the inquiry report submitted by Sri Pradip Das, the DSS Sonipur regarding irregular appointment in Corporation Department for favor of perusal. It may be mentioned that this office has already intimated the same by letter under reference, for which the reply is still awaited. In view of the observation made in the aforesaid inquiry report, the undersigned seeks approval to start department proceedings for termination of service of employees who were appointed irregularly. Furthermore, you are requested to refer the matter of illegal appointment to an investigating agency to conduct the detailed investigation of the matter. So, without adhering to the rules 9 of the Assam Appeal and Discipline rules, the petitioner, the respondent too has sought for approval to start department proceedings for termination of service. There is a predetermination of guilt against the petitioner for to deny him the service benefit. The Honorable other coordinator benches has passed similar order in this regard, reviewing order.
You are agreed by this communication?
Yes, yes. Other bench has preferred a repetition, and the other coordinator bench has passed interim order in this regard.
See, inquiry report has been submitted. DP has completed.
No, not as that. There is an interim order in the favor of other petitioners.
Now, what is this writ petition at page 10?
The petitioner, other petitioners who are affected by the interim order has sought repetition.
No, see, I don't understand your case. Thing is that there's one writ petition at page 37. You were also a petitioner there.
No. I have annexed the similar order of other petitioners. The lawsuit other coordinator basis has passed a similar interim order.
What do you mean? See, please come to page 39. Your name is there, Bholaram Saikia.
This is the previous litigation.
That is what I'm asking you.
Yes.
What is this previous case about?
Previously, the salary was stopped
Huh.
by the respondent authorities. So after filing the previous petition, the salary was allowed. And
Previous writ petition was for salary only.
yes, the salary also.
So any departmental proceeding was drawn against you that time?
No.
No. What are you working as?
I'm working as a peon.
In the office of the
Office of the Deputy Registrar of Corporate Society, Nagaon.
cooperative societies. So your salary was stopped?
And after that, as per order of the Honorable High Court, salary was released, and there was an observation in this regard.
Your appointment has found to be invalid. or what?
Irregular.
Irregular. So thereafter, they have issued this order
Yes, order.
at
After
page 40. What is this page?
Page 44.
Page 44. Some inquiry was done or what?
The inquiry was done, but not adhering to the rules under Rule 9 of the Assam Appeal and Discipline rules.
I see.
Because
So what is the other interim orders? This one?
Yes.
Yes, Mr. Counsel, what do you say?
Your Lordship, I am appearing on behalf of Standing Council of Corporation Department, Mr. Firas, Your Lordship. Your Lordship, regarding the matter, Your Lordship, we have to wait for the instruction, Your Lordship. And
Don't initiate the proceeding. You obtain the instruction. Interim order will be given. It appears that you have not adhered to Rule 9 of the Assam Public, some disciplinary rules.
1964.
Please write, by filing this writ petition, the petitioner has challenged the communication dated 30/1/2024, by which an approval has been sought by the Register of Cooperative Societies from the Secretary to the Government of Assam Cooperation Department to initiate departmental proceedings against the petitioner and other similar situated persons who have been found to have been irregularly appointed as per the inquiry submitted by one Sri Pradeep Das, Deputy Registrar, Cooperative Societies, Sonitpur. Stop. The Learned Council submits that no proceeding under the, what is the name of that?
Assam Services Discipline Appeal Rules 1964.
Assam Services
Discipline
Discipline and Appeal Rules 1964 has been followed. Where is the first interim order?
Page 75.
You have annexed it.
Yes, I have annexed it.
But Mr. Counsel, there's one thing. That inquiry report, is it not a preliminary report?
It is not a report under fine.
No, Rule 9 will come later on. Before applying Rule 9, some preliminary inquiry has been made whether there's anything against you. And when the authority found that there's something against you, then he has sought for the consent approval. So then that Rule 9 will be followed after that.
Because the predetermination of guilt against the determined proceedings for termination of service. The predetermination of guilt to deny the service benefit of the petitioner. Because already they have made up a mind that for termination of service. The letter says so. And except 44.
What did I say last? Followed. And that the respondent authority concerned through the impugned communication has predetermined that the petitioner and other similarly situated persons should be terminated from service. Next para, in view of above, issue notice of motion returnable by 4 weeks. Mr.
A.J. Sharma.
A.J.
Sharma.
A.J. Sharma, Learned Counsel, accepts notice on behalf of Mr. Raj Gowa.
P.
For Victory.
Victory.
Mr. V. Raj Gowa, Learned Standing Counsel, Corporation Department. Yes. Petitioner to serve requisite extra copies of the writ petition. Who are the respondents here?
All response. All response.
What I say? Who represents all the respondents? Okay, stop. Petitioner to serve requisite extra copies of the petition to the learned counsel appearing today within 2 days. In the interim, hereby directed that till the next returnable date, no coercive steps should be taken against the petition. There was one case, you see. There was one case. You conduct the inquiry. The authority has directed, you conduct the inquiry with the aim to dismiss this person from service.
Yes, sir. This,
Something like that.
yes, I have the case.
That case pertains to an outline bench.
Yes, yes.
Some outline bench. It says that you conduct the inquiry with a view to remove that person from service. So that premeditation is there, isn't it? Anyway.
Otherwise.
Yes.
May I please address?
Yes.
Petitioner earlier served as a deputy manager in the organization of Assam Petrochemicals, and he has resigned from that office in the year 2011. And thereafter he joined Brahmotra Cracker Polymer Limited as a deputy manager. Now, during his tenure, my lord, his earlier pay was revised, and he submitted for various representatives for implementation of his new pay revision. Now, lordships, kindly see page 28. Page 28 and
yes.
one. This is to certify that so-and-so, so-and-so, so-and-so served in this organization since December 1997, released from the service of the company on resignation on 30 September 2011. Based on the revised pay scale of the company, which was effective from 1st April 2009 and implemented in the month of so-and-so, his monthly pay as on the date of release from the service of the company is calculated as under. Pay in the pay band so-and-so, basic pay 31,210. Now on this basis, in the new organization, he has submitted representation for implementation of the new revised basic pay.
Where's the representation?
Losses page 29. From 29 onwards, he has submitted up to lordship will find page up to 35. Various representation has been submitted for protection of his pay structure. Now, from 2013 to 2016, in the year 2016, Milord, page 36, they have responded. Page 36.
What is BCPL?
Brahmoputra Cracker Polymer Limited. It's a government of India undertaking, Milord.
Respondent number?
Respondent number 228, Milord.
228.
Yes. So MD is there, Milord. Then GM is there.
Earlier, you were working under
Assam Petrochemicals, that I have shown page 28, Milord. Assam Petrochemicals Limited, page 28.
will issue notice.
Yes, yes, Milord.
Heard Mr.
S. Sharma, Milord.
S. Sharma, learned counsel for the petitioner, who submits that the petitioner was earlier working under the Assam Petrochemicals Limited. With a certain pay band. With pay band of rupees 12,000-40,000.
My lord.
Correct? Stop. Thereafter, he has joined MS Brahmaputra Cracker and Polymer Limited, bracket BCPL. where he has prayed for his pay protection by submitting representations as far back as on 9/9/2013. Stop. However, since the benefit of pay protection has not been given to him, he is before this court. Next para, issue notice of motion returnable by 4 weeks. Anyone appearing?
Respondent number 1.
Your good name?
Yes, Bhattacharya.
Mr. P.S. Bhattacharya, Lanet CGC, accepts notice on behalf of respondent number 1. Petitioner to serve requisite extra copies of the writ petition to him. Stop. The petitioner shall serve notice. Petitioner shall take steps for service of notice upon the remaining respondents. How? Registered post?
Registered post.
By way of registered post with ADD within 3 days. Yes.
All right.
My pleasure. My lord, this case relates to the promotion from assistant development officer to development officer in the tourism department. Yeah, what happened, my lord? My name appeared at serial number 1 in the final gradation list, my lord. Thereafter, my lord, private.
Yes.
Thereafter, my lord, private respondent number 6 filed a writ petition, my lord. She hails from BTC, my lord, want to club in the state list, my lord. Anyway, my lord, that case is subject matter is different. Now, my lord, APSC has conducted 12 number of posts, my lord. They are likely to appoint, my lord. As per rule 22 of our service rule, my lord, lordship, kindly have a look, my lord. Yes, may rule 22. Yes. 22 Nigri. 22, 3, my lord, lordship, kindly have a look. It says, my lord, if the direct recruitment is being made, promotion will be counted from that particular year. And since, my lord, APSC has already conducted 22 subclause 3, my lord.
A member appointed to a cadre.
My lord. If it is appointed in the same year, then only, my lord, my senior will be counted. Yeah. And to that effect, my lord, APSC has already conducted an interview process, my lord. That your lordship will see page 43 and 44.
You are a direct recruitment.
Yes,
Direct
I'm
recruit.
direct.
You are a direct recruit.
No, my lord, I am assistant development officer. My next promotion is the development officer.
Okay. So
Now, my lord, there is a 12 number of posts for direct recruitment and 1 post for the promotion, which is the subject matter filed by the private respondent number 6 in different matter, my lord. Now, my lord, my queries and my anxiety is that, my lord, if that recruitee are appointed, my lord, if my promotion is not considered in a particular year, my lord, my seniority will be below them. So my only prayer at this stage, my lord, lordship issue the notice and case may be clubbed with that particular case, my lord, which I have already annexed, my lord. And my lord, any appointment made, my lord, shall be subject to the outcome of the writ petition so far seniority is concerned. Only that much.
So in an appointment in the same year,
yes,
the promotee will be senior.
Promoter will be senior. I am the promoter.
Direct recruit will be lower. As per this rule 22(3).
22, my lord. That is my case. So at this stage, my lord, notice may be issued. And my lord, the recruitment process which they have made, my lord, page 43, my lord, shall be subject to the outcome of the writ petition so far seniority is concerned. Only that much, my lord.
43.
Page 43, Lordship, kindly have a look.
How many posts?
12 posts, my lord. Alage. 12 categories 24, promotion 12 and direct recruitment 12. 44 will be clear, my lord.
No, total post is 12.
12 for direct recruitment and
The-
promotional 12.
Where is promotion? This is only for direct.
Yes, this is the direct.
Hmm.
If direct person comes, my lord, my seniority will be below them.
What is the stage of the consideration of the promotion?
Promotion is my finalized, my lord, but due to pendency of the another writ petition, my promotion has not been given effect. Despite of fact that, my
Where
lord,
is
I'm
that?
number one.
Where is that?
Yes, my lord, I'm coming, my lord. That your lordship will see at page. Before coming to that, my lord, lordship kindly see my seniority position, my lord, page 29. Which has been finalized at page 30. Seniority list code.
Page 30 is
Just a minute,
redesignation.
my lord. Sorry. No, no, what is it?
Annexure number.
Yes, I'm coming, my lord. Tradition list code.
Page
Page 40, 40. Sorry,
40.
40. My seniority stands at serial number 1,
It is not 40. Page 41, I think.
my lord. 40, 41, my lord, is connected piece.
Gautam Gogoi.
My lord,
This is the petitioner.
my lord.
So among the promotees, you are at serial number 1.
My lord.
There's another different process through the direct recruitment,
My
which has been advertised.
Yes,
You are apprehending that it might be completed before you are promoted.
yes.
Now,
Only subject to the outcome of the writ petition, that much will do.
No, my lord, this cannot take care.
Because, my lord,
Different process.
my
no,
lord, that is-
where is that writ petition?
my lord, I'm coming. to
Show
that.
me that writ petition.
Yes, I have annexed the order, my lord. Lordship kindly see at page starts from 32,
32.
my lord. Stay is operative.
32.
Yes, my lord. Operative pass is 30.
Why don't you file an IA in that case?
Yes, IA is there.
Seeking the
IA
vacation
is
of-
there.
Where?
IA is there for vacating the stay order.
So what has happened to that?
It is fixed on 9th January.
You concentrate on that.
Yes, that will
Now,
do, my lord. What
but
I want, my
why
lord,
you want to file this writ petition?
because, my lord, my rule 22 will be affected, my lord. I want protection for rule 22(3). That much. That is my case.
See, that cannot be a case like that, no?
My lord, suppose, assuming, my lord, if the appointment is made next year,
I understand your apprehension, but how do you, how can you stall that?
no, I'm not stalling, my lord. I'm not affecting, I'm not challenging
No,
their
how,
appointment.
how can you,
Only, my lord, the rule 22(3) to be followed by the authority. That much.
that they will follow.
No, they are not, they will not
The rule
follow,
is
my
made to be followed. If they don't follow, then you come. In anticipation that they will not follow, how you're coming to the court? You move the IA, say that, see,
Or,
let
my
the,
lord, one
let
thing,
the
my lord.
promotion be allowed, and this promotion would be subject to the outcome, because you are the senior most. That petition is not above you, isn't it?
I have not filed. I got implemented in that particular.
He does not, or he or she,
She,
She does not dispute that you are senior.
Yes, she does. She
Then,
cannot.
then you ask the court that you should be promoted, subject to.
No, no, my lord. Here, my lord, my case is specific, my lord. I am not against the direct recruitment or anything. Only, my lord, my seniority to be protected. Notice may be issued, my lord, lordship passed, my lord, appropriate order after hearing, my lord, all the sides. Only, my lord, along with that petition be clubbed, my lord.
Seniority be protected, how?
My lord, rule 22(3) has to be followed.
So in anticipation that rule 22(3) will not be followed, how can you file a writ petition?
And there,
Cause of action has not arisen now.
my lord, the process.
If they
that
don't follow
seems to
it,
be
later
that.
on you
Process
follow up.
seems to be that.
I think it's
No, my lord, that recourse will take differently. My lord. Now, my lord, only for the protection of rule 22.
see, one person has come to the court saying that in the gradation list, my name is not there. Court says that, okay, no promotion. Then you are affected by that order because you are senior and you should be promoted. Because of that order, you cannot be promoted. Go and ask for vacation of the order or
Suppose, my lord,
modification of the
rule
order.
22(3).
Now, this direct recruitment process is a different process.
Yes, different process.
You are a promotee,
I am the promoter.
aspiring to be promoted.
Yes, my lord.
Direct recruitment has no link with you, only later on the seniority.
My lord, what I want, my
You
lord.
want your seniority to be kept protected like that. How can we do that in such a manner?
My lord, since rule 22(3) says, my lord, it is a very much clear, my lord. I am not disturbing any appointment or anything, any recruitment. Only, my lord, let them adhere, my lord, the provisions of rule 22 sub rule 3. That much.
It's premature.
My lord, at
cannot
this
pass
stage,
such
my
kind of
lord,
order.
notice may be issued and class cases be.
No, notice cannot be issued just for the sake of issuing notice. We'll issue notice when there is a case.
My lord,
Mr.
cases only.
Borgia, I don't think this is the time to file this writ petition like that. You pursue that other writ petition by filing that IA and get the get the stay
No,
modified.
one, my lord, let the matter be clubbed with that petition. Because there I am not the petitioner. It is the case.
In that case, you're not the petitioner.
I'm not the petitioner.
Have you been impleaded as a
I got
respondent?
impleted. I got impleted,
You
my
got
lord.
impleted.
But being a respondent, my lord, my saying is not that much, my lord, because I need to have some writ petition, my lord, to get protected, my lord.
No, why do we club? How do we club together? Because these are two different lines.
My lord.
One is promotion line, one is direct
That
recruitment line.
promotion line, my lord, she has already filed a writ petition, private response number 6.
You're filing this writ petition perhaps as an abundant precaution.
In other words, it is so, my lord, but even though, my lord.
But that situation has not arisen. Had it been a direct, had it been a promotion line, I understand, but it's not a promotion line, it's a direct line.
My lord,
I
I
don't
am, my
think-
lord, seeking promotion in persons to the law available there. Here, my lord, the law says, my lord, direct recruitment will be below me if in the same year is not appointed. Suppose, my lord, it has not been, they have been appointed, I was not been promoted to my particular post.
Mr. Borbuya, I have to. I think I have to dismiss your writ petition. But liberty will be granted to you if you want, whenever you have time. The
Not to
situation
dismiss, my
demands.
lord, lordship fixed the other day, my lord. In the meantime, I'll take instruction. If, my lord, necessary, we'll withdraw the writ petition, my lord, before getting any dismissal order. Any day next week, it may come up. Because, my lord, the right has been accrued by virtue of rule.
Okay.
Right, my lord. No right has been accrued, my lord. My lord, here is the case. My lord, the direct recruitive are yet to be, my lord.
I am not disturbing, my lord, my recruitive. My learned friend is.
Let me pass the order. I have understood the case.
My lord.
We'll adjourn it to some other date. Okay?
Yes, my lord. Any date convenient to your lordship, madam.
The petitioner is an aspirant for promotion from the post of Assistant Development Officer to the post of Development Officer. Stop. As per the relevant recruitment rules, the post of Development Officer can also be filled up by way of direct recruitment. Stop. Since another person holding the post of Assistant Development Officer
In BTC.
in BTC, having not found her or he
He.
herself to be amongst the officers listed in the gradation list, has filed WPC
My lord, two writ petitions he has filed, my lord.
2.
Two. Number,
What
my
are
lord,
those?
5568 of 22
5568 of 2022
and 659 of 22.
659 of 2022,
My lord.
and has obtained an interim order to the effect that no promotion should be made to the post of Development Officer. Now, according to the present petitioner, if direct appointment is made in the meantime, the petitioner is bound to lose his seniority because of the interim order, and in view of the provisions of Rule 22(3) of the what is the name of this rules?
Given to your lordship, my lord.
Of the Assam Tourism Service Rules, 1992. Of the petitioner, therefore, by filing this writ petition, prays for an observation by the court that the respondents should follow Rule 22(3) of the said rules. Stop. However, this court is of the considered view that this court is of the prima facie view that the writ petition is premature. Next para, Mr. J.R. Borbuya, Learned Counsel, submits that he may be given some time to obtain instructions from his client. Stop. In view of above, matter stands adjourned.
And one more thing to be added, my lord, because in the meantime, my lord, direct recruitment process is going on in respect of 12 number of posts, page 43.
I'm not saying anything. I'm not issuing notice also.
No, my lord, that will do, my lord.
Ah.
Lordship at least
What?
pass some order, my lord, observation, I mean to say.
Not required. No observation. I've just given a brief background so that we don't forget next time what has happened. Yes.
Can I take back, my lord, please?
Just again after a week.
Can I
Surely
take-
you can take it. Just again after a week as prayed for. Item 9, yes.
On a petition for lordship, the widow of the his husband was died on 2/8/2018 while working as a Nayak of Assam Civil Reserve Police Force Assam. And in fact, Malad, his husband, her husband's first wife was died in 2006. Prior to his death, Malad, the petitioner got married in 2007. Now in 2018, soon after her, the husband's death, the department authority issued a condolence message to her. Annex A1 is the condolence message,
Page.
Page 20,
Petitioner is the wife.
Wife,
How many
And
wives did he
copy
have?
to page 21, serial number 8. Copy to mark to her, the petitioner, wife of late Subal Bara. Then,
Jyoti Kaur.
Annex 2 is the death certificate. It is indicated date on 2/7/2018. And her name is there, Jyoti Kalita is written over here. In Annex 3, there is page 24. The authority, the commandant of the ASRF Battalion 2, Kamargaon, issued this letter for submission of document for preparation of compensation of family pension. This document, the petitioner has submitted immediately. Annex 25 is the next kin certificate. Page 25, Annex 4.
Yes.
Annex page 26, the next skin is given there. Serial number 1 is the mother of the deceased husband. Serial number 2 is the petitioner herself. Serial number 3 and 4 are the daughter of the deceased husband. This is the family one. Annex 5 is page 27 is a document where the department authority, the commandant, wrote a letter to the one of her daughter, that means husband's daughter. So submit this document for preparation of the family pension. So what happened in the meantime, in 2019, he submitted all these documents as per the 2018 letter, Annex 3, before the authority. In 2019, the two daughter and the mother-in-law submitted that succession certificate, succession case before the district court. Annex 6 is the judgment and order of the district, additional district judge. Subsequently,
You see,
subsequently,
just a minute.
against this order.
Just a minute. Annexure 3 is the submission for documents required. That was in 2018.
18.
You have submitted.
I immediately submitted.
Why again they have asked for
Due to
some
this
more
succession-
documents?
Possible due to the succession case. The district does help that all of the, it is required to be distributed. The family that schedule given there in the year, this is the pensionable.
Where is the schedule?
Schedules
Who filed the succession?
that the mother-in-law and two daughters, because the two daughters are her first wife's, the husband's first wife's daughter.
Oh,
They
two
before
daughters are the stepdaughters.
my lord,
Wife is the second wife.
second wife.
And where's the first wife?
First wife was died
Expired.
in 2006.
First
After
wife expired.
Her died.
Just a minute. First wife and the deceased government servant had two daughters.
Two daughters.
Then he expired.
He
No, sorry.
expired in 2018 and
He-
first wife expired in
What-
2006.
And before her expiry, the husband had married again.
Married in
The present,
2007.
the present petitioner.
Well,
So she submitted the documents for compassionate family pension, but
except serial number
the mother-in-law and the daughters
Malo.
filed succession.
Malo.
So that has complicated it.
That is why it was held up now, not issued. Subsequently, the judgment is delivered accordingly, the page 36.
Yes.
The decision is given operative person. Against that, we prefer the instant case and the appeal, Annex 7, before this honorable court. This honorable court has, having found a prima facie case, stayed the judgment passed by the succession case, district judge judgment. So my humble prayer to lordships, as far as pension rule, rule 143 is very specific of the pension rule.
What is
I
there?
have quoted that rule in the,
Page-
petition.
Page,
Page, my lord, 11, para 10, my lord. And your lord says this is the rule, my lord. Your lord says go through the rule also,
143(1).
my lord.
Pension, the family includes wife, husband, minor sons, unmarried daughters. Which provision you want me to see?
143, my lord, marriage for a my lord, my lord. In case of a widow, note 2, my lord,
Note 2.
widower up to date of her or his death, remarried, whichever is earlier. In case of minor, so and so is not relevant, because I am still, my lord, remain as a housewife of that family. So
So,
definitely, being a widow, I am entitled, my lord.
You are referring to which provision? Relying upon to which provision?
Rule 143,
Yes.
my lord, note 1,
Note 1.
provision, Roman 2A,
2A.
my lord.
Yes.
In case of a widower, up to the date of her or his death or remarriage, whichever is earlier, pension is admissible to me, I being the widow. So when rule is specific, the succession case, that is why prima facie found the illegality of the judgment passed by the not impugn, the judgment passed by the district authority. This honorable in the appeal.
What happened?
stayed that order.
What happened to that case?
That has been pending.
Still pending.
It's still pending because.
So in the meantime, what do you want with this case?
Since the rule is specific, the rules was not interpreted before the succession code or anywhere. The state government employee, the pension rule is applicable, and as per this rule, only when widow is entitled. So the Department authority, because I am without any money, no source of income, provisional pension also not disbursed to me, I am nowhere, without any other income source, From my humble prayer for losses, since rule is specific, so in time at least provisional pension is required to be paid since 2018. It is difficult for a widow without any source of income. That is why I am before your losses, so that
That is, you have come before the court through this intest. What is this intest?
that is the appeal against that succession case, order passed by the district.
So you pursue this case first.
Because it's a pension matter, government employee, the succession, they are not entitled to get the pensionable amount by way of succession. The rule is very specific. It's provided when because both the daughters were already married.
So that will be touching upon the appeal filed by you. You pursue that matter at this stage. What direction can be passed?
Because rule is very specific. At least provisional pension, this entitlement due to an widow,
See, minus the
prevented by any other way,
minus the succession certificate, perhaps we could have considered giving that direction. But with the succession certificate already there,
that has been
how do we
appellate
ignore?
Authority, this honorable court.
It is an interim order of stay only.
Case, it is stayed, but ordered at the 21/8/2024, That is why I am before losses. Why? Because
what anyone appearing? Yes, Mr. D. Bora.
Lordship, first and foremost, this particular writ petition is premature. And if your lordship may kindly go to if your lordship peruses the Indian Succession Act, as per section 370, succession certificate is issued in terms of a death. Now, pension as such is considered to be a debt by many, by the Honorable Supreme Court in many.
In terms of a debt.
Debt, DEBT. So it is considered to be a debt. Now, if your lordship peruses through the Indian Succession Act, if your lordship Succession Act. So that that particular succession certificate is issued by the district judge. Here in this case, the additional district judge, which is under challenge before this Honorable High Court and which has a stay. Now, during the pendency of that particular issue, I ask myself, can this Honorable Court seize hold of this matter? Because if the succession certificate is
That is
required-
what I was also thinking.
Yes.
You have repeated what I've said. What to do?
But one aspect of the matter is very
You can
clear.
only issue notice at this stage.
I'm, your losses,
nothing
take a
beyond that.
decision. I have no, but one submission, my lord. It is, I am open, my lord. I am before losses pointed out there is succession case and it is before the appellate authority state the succession order, my lord. The kid's husband was a government employee. It is covered by the pension rule, my lord. Family pension is governed by the rule 143. In the succession case, specifically they were seeking succession to particular amount that I indicated in my representation 641. This was the schedule which was under the succession. 14 lakhs, this amount. Gratuity, encashment, family pension, other things.
Your lordship may also go to page number 27 of the petition.
That was
Why this
already pointed
particular
out.
Succession certificate is important, your lordship. Because the department themselves are actually sought for that particular succession certificate. If your lordship uses section 370 of the Indian Succession Act.
Three seven zero.
370. More particularly, I'll just read out, Your Lordship.
Yes.
A succession certificate in this part shall not be granted under this part with respect to any debt or security to which a right is required by section 212 or 213 to be established by letters of administration or probate, which in this case there was no letters of administration or probate. Provided nothing contained in this section shall be deemed to prevent the grant of a certificate to any person claiming to be entitled to the effects of a deceased Indian Christian or to any part thereof with regard to any debt or security by reason that a right thereto can be established by letters of this administration under this act. Now, for the purpose of this part, security means security we are not concerned, Your Lordship. So here, next section, Your Lordship. Under section 371, the district judge is empowered to issue the succession certificate, which in this case has been done. So this succession certificate, Your Lordship, this is under dispute. This particular issue is under dispute because the learned district judge has actually issued the succession certificate in favor of the mother and the two daughters of the earlier wife. Now that is under dispute and which is stayed by the Honorable Court in the appeal filed by the petitioner herself. So that's why I'm saying this particular reposition is premature. Let this particular issue be resolved, then whoever gets a succession certificate, they will get this compassionate family pension.
Indirectly, this
Now, if suppose provisional pension is granted to the wife, and if suppose she is not successful in the appeal, then who will recover? How will we recover that particular amount?
Indirectly, the submission made by the learned, my counterpart, is that the rule which is governed by the pension rule, which is governed by a service holder, is required to be, since the other side, that means daughter, that response number 3, 4, 5, 6 has filed the succession certificate wrongly. It should be ignored the rule 143. If that is the submission, I could not understand a service holder retired and widower is not entitled not covered by section 143. That's horrible, Malat.
Patient certificate has been granted. So in that,
That is a wrong.
so that's
my
why you
submission
challenge.
were all that process.
You
was
challenge it.
totally
Let the
wrong.
matter be disposed. Then we'll consider.
Malat, she
As
is in
on
a
today, I don't
difficult position. Malat, maybe she will die within a short,
Maybe.
Malat, without any money, Malat. She is entitlement, Malat. Rule 143, I pointed out, Malat. This is a government employee to service, but pension is, family pension is governed by this.
Nothing much can be done. I'll just issue notice. That's all.
My humble prayer, Lord, says some protection. Otherwise, it will be become infructuous. That is the situation, as of today,
It will not become infructuous. Why should it become infructuous?
The person will be no longer.
You pursue. You have filed your what you call appeal on that succession certificate.
That is there, But
it's there.
Since she is
You pursue that.
legally entitled, that is why I am.
You pursue that succession appeal.
Since she is legally entitled under 143, the family pension.
Heard, Mr. UK Goswami. Mr. UK Goswami. UK Goswami, learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner seeks for a direction to the respondents to grant her compassionate family pension.
As well as the regular family.
Compassionate family pension, family pension and other pensionary benefits, including all service benefits. To stop, the petitioner is the widow of a deceased. What was he? Constable?
Nayak.
Of a deceased Nayak.
Nayak in Assam Special Reserve Police Force.
In the Assam Special Reserve Police, Assam Special Reserve Force, Bijni. To stop, the employee initially was married to another lady, and from whom they had 2 children.
3 daughters.
One died.
One died.
Had 3 children, had 3 daughters. And out of which one of them has expired. Stop, the employee and the earlier wife has expired. And according to the present petitioner, being the widow, being the surviving widow, she is entitled to be given compassionate family pension along with all other pensionary benefits to her in terms of Rule 143. In terms of note, where's the book?
Yes, 12.
Page 12 in this book.
Of the writ petition,
No, I'm looking at the book. Because
159 pages in my book, Malat. Woman to pension is under this rule in this section will not be payable to more than one member of an officer's family at the same time.
In terms of Rule 143, bracket small Roman 2, bracket small a of the Assam Services Pension Rules 1969. Pension will be within bracket.
And may I point out, Malad, Roman 3 indicates that cannot be disbursed to payable to more than one person, the family pension.
Next para, the Learned Counsel further submits that the mother-in-law of the petitioner and the two stepdaughters have filed succession case, and the court of the additional district judge has granted succession certificate in their favor, which the petitioner has also challenged by filing an appeal before this court.
Page 38.
What is the full form of INTS? Intestate case.
Intestate case.
Intestate case 4 of 24.
Namely, intestate case 4 of 2024, page 38. Okay. The said appeal is said to be pending as on date. You are referring to which loss? More than one person, you said?
Malad, Malad, note 2, Roman 3 is there, Malad.
Note 2 below which section?
Malad, 143, Malad.
See, 143 has got paragraph 1, Roman 1. It has got paragraph Roman 2 also.
And Roman 3 also.
And notes are under both.
Malad, Roman 3 also, Malad.
Now, so that note will be under which, Roman 3 or Roman 2 or Roman 1? Which one?
Malad, C Roman, Masoli 3 is the independent one. Roman 3. Malad,
Roman 3.
Note 1, Malad, is.
There's no note under Roman 3.
Note 1 is also in between there, Malad. It's confusing, Malad. It is written over. Immediately thereafter, note 1 is there. Then Roman 3.
Numbering is not correct.
Numbering is also confusing, Malad, but it is already.
So pension is normally given to one only
Malad.
at any rate. And if it's under the Muslim law, then there's some
Altogether different, their judgment is there, Malad.
elder one.
Elder one.
And they also have some sort of
First
settlement.
The first wife will be.
There is also a settlement, isn't it?
Yes, yes.
That this share 50-50 or 40-60
Yes,
like
it
that.
will be divided equally among all the 4 wives.
Several
Till-
case laws are
till
there.
4. There is a full bench judgment of the Samlo court, Your Lordship.
But here it is not applicable. Malad, here the Roman 3, only one person can.
The Learned Counsel submits that as per the pension rules, only one person is entitled to be given the pensionary benefit.
At the same time.
And therefore, the succession certificate granted in favor of the stepmother and the in favor of the mother-in-law and the two stepdaughters is illegal. He therefore submits that an interim order may be passed in favor of the petitioner for grant of provisional pension. Next para. However, considering the fact that however, he cancelled it. Next para. In view of above, issue notice of motion returnable by 4 weeks. Mr. D. Bora, Lanet, Government Advocate accepts notice on behalf of the
1, 2, 3.
respondent numbers 1, 2, and 3. Petitioner to serve requisite extra copies of the writ petition to the Learned Government Advocate within 2 days. Let steps be taken for service of notice upon the respondent numbers 4, 5, and 6 by registered post with AD within 3 days. Next para. Having regard to the fact that the succession certificate, a succession certificate has been issued in favor of the private respondents, and that the instant petitioner has also filed an appeal. The prayer for interim order at this stage is declined. Yes. Okay, we'll assemble at 2 then.
May it be lots of matter. Before I start with this petition matter, there was a petition filed earlier matter, where there was interim order also, granted 3/5/2024. But there are some paragraphs are jumbled, my lord. So we had to withdraw that petition on 26th of November and file this fresh petition on 29th of November immediately. In that petition, my paragraph 36 I have stated, there is liberty given to file afresh. Because there was a early petition was the paragraphs were 10 was numbered as 18, 18 was 26, so there was withdrawn. So now this petition, same order challenge as was in the earlier petition matter by virtue of this petition.
Which one are we taking up first?
33 my lord.
33, yes.
6 6561. The contents are same in both the petitions. You also can also take 6685 of 2024. Here, my lord, whatever the list the dispute starts, my lord, by forming an union by us. I was elected president. There are 60 employees as staff nurses in the mental hospital Tezpur. Lokapiriya Govinda Bardole, Institute of Mental Sciences, Tezpur. And the authority took my lord, annoyance on forming the union. There that you should be taken the permission for forming the union. But under the law, that Union Act, there is no such provision required to either intimate or even to take permission. However, we intimated them about the formation of the institution matter. I have annexed that letter also. Now I will also kindly come to page 3941st, where the union was formed. And it was registered also under the Trade Union Act. Section 4 and 5 of the Trade Union Act.
39 is memorandum.
Yes, that was the my lord registration of our trade union.
Where is the registration? This is a memorandum, page 39.
Sorry, my lord. Oh, there are two copies. Just a minute. Your lordship is taking 6685.
No, the 6561.
No, sorry, my lord, your lordship may take 6685, the new matter. Insurance cause of action, right, Your Honor.
Page
39.
yes, 39. This is a certificate.
Yeah, there is a certificate only issued by the trade union authorities, annexed D. It certified that so and so nurse situation Tezpur Major Bekasuri is and registered under so and so on 10th day of November 2022. The meeting to form the association is at 40 my road. Next page. Next page. I was elected as my lord president. Departmental Naidu is my name.
Association by nurses.
Nurses.
What is your case regarding?
Yes, my lord, this they have taken as a my lord annoyance for forming the association. And why the association formed, my lord? The lordship will have to first come to the my lord timing of the working time of the mental hospital. We have represented that working time of the mental hospital. In mental hospital to work for a nurse is very risky because the mentally deranged people are kept there. So, like the AIMS or other mental institutes in India, our working time should be same. In that, the authority did not agree, did not reply also. That I have annexed it, my lord, annex 35, sorry, page 35 to 38. Then we have to form the association to my lord address our grievances. This is the form. Then they also kindly come.
But the petitioner before the court is individual person.
Because he was charged individually.
Who is he?
Dharman Naidu, president of the association. Dharman Naidu, the petitioner is the president of the association.
Okay. He is also a nurse.
Yes, it's not.
Male nurse.
Male nurses. Male, female altogether. There are 60, male, female altogether. Because it is very difficult for the female alone to work in mental hospital. There are lots of the risk. Age 50 is my lord. Our intimation to the authorities that we have formed this association.
Page 50.
Yes.
Yes.
Now they are insisting on permission. We said there is no permission required under the Trade Union Act. It is a voluntary association of the employees. So such permission is not required. Then, my lord, they took a, my lord, annoyance and issued a annexure I, page 56. Annexure I, page 56, will also kindly come. Establishment of LGBRIMS Nurse Institution in Tezpur, so. In reference to the communication dated 22/11/2022 and 4/12/2022, this is to be intimated that you have failed to provide desired information as asked by the authority. They are seeking for permission. We didn't obtain prior permission. That is not required also. This is also to be informed pertaining to the joint representation from your end. The letter addressed by the association union was taken to be joint representation from your end, and as referred above, that submission of same against common interest is considered to be subversive of official discipline and serious misconduct. The correspondence made in the name of union. There is no cause to be annoyed. I didn't write alone. All letters are correspondence are made in the name of the union. And later, my last, this is issued as per approval of the director. This is also illegal. Any initiation of proceeding under the bylaws and the constitution of the institute is to be done by the director, the disciplinary authority, the appointing authority, not by any other orders. OSD. and there is no post of deputy director in the my lord bylaws. He total unauthorized officer. Now let's kindly come to. We have replied to that. Then a legal notice was issued by an advocate, my lord, ventilating the grievances to the concerned Ministry of Health and Family Welfare, Government of India. Your lordship will find at space 61 to 62, Annexure L. Your lordship, what my lord? This was addressed to the, and also Director General of Health Services. This was addressed to the Government of India and the Director. Against this, my lord, they have issued suspension order, my lord, directly on 8/1/2024, my lord, Annexure P, page 68. The second paragraph, Mr. Dharmendra Naidu also instructed to file baseless complaint against the institute and its authorities to the ministry by passing the prescribed official channel during the inquiry as instructed by the ministry. Mr. Dharmendra Naidu claimed that the filed the complaint is association with other staff nurses of the institute, which was found not to be true. All the pads and everything corresponds in the name of the institution. The seal is in the name of the institution. Then my next paragraph, next page. Then ultimately they suspend me. I have challenged that also in the early repetition. Then also will kindly come directly to the charge sheet, page 81. Page 81. I have been charged with number one, charge. Dharmendra Naidu attempted to bring the influence of an outside agency, who is the financing and controlling agency, government is the financing and controlling agency, on the institute authority on the service matter by filing false and baseless complaint on 7/7/2023. 7/7/2023 is the legal notice, my lord, which I have shown your lordships. The legal notice. Then again, charge number 2. Dharmendra Naidu, staff nurse, is instructed to file false and baseless complaint to the ministry and outside authorities against the institute by letter dated so and so, stating that the institute has imposed unreasonable duty timing for his staff nurse, violating relevant rules, norms, while asking to submit records to substantiate his allegations. He failed to do so. Then filing false and misleading complaint against the one's own institute and acting to defame its name and fame is an unbecoming conduct of an institute servant, is violation of Article Rule 313 of CSS conduct. I'll show your lordship the 313 also. Like that. Then Article 4 also same, based on legal notice. I submit whether giving legal notice is a serious misconduct, whether the controlling and financing authority is outside agency that tried to influence it. That was also entire proceeding was stated in the earlier repetition. Then my lord will kindly come to, we reply to that by annexure T. Then inquiry officer appointed. Then I will come to 114 page number. Page 114.
Yes.
This is the stay order of this court, my lord, dated 3/5/2024.
This is filed in
My lord,
which writ petition?
this, the
Two,
very
three.
question.
2, 3.
60 double.
No,
The earlier was 2356.
you have withdrawn that
We don't with liberty.
and you have filed the new one.
New-
That
new
is
one.
66561.
And my lord, another one. 6561 and this one present one 6685.
Why did you withdraw?
There was some paragraphs are jumbled, my lord.
Paragraphs are jumbled.
Yes, that's why I have made a clear statement in paragraph 36 of the petition. This petition also.
So now what do you want?
My lord, now they have issued a fresh order, my lord, on 4 December 2024, they also kindly come. The portion was state, then you know, annex AX is 117, the ultimate one.
117.
117,
Okay.
last one.
Hmm.
May the also go to my lord.
Hmm.
117 annex X, my lord.
Yes.
In reference to the Honorable High Court order dated 26/11/2024, passed in respect of WPC 2356/2024, filed by the by Mr. Departmental Pradhan, Established, wherein it is stated that the WPC number stands disposed of on withdrawal with liberty to file afresh. The competent authority hereby instruct to continue the decision proceeding initiated while charge number so and so was issued 4/4/2024. This is the issue by the officiating director.
Where is this order dated 26/11/24?
26/11/2000.
Order of withdrawal?
That I have, my lord, stated in paragraph 36 can come.
No, you have not annexed a copy of the order.
No, that was not the next, my lord.
Why?
I have made the statement, my lord. And that also they have admitted in their implement order also.
No, court would like to see also what kind of order was that. After you withdraw,
Yes.
stay has been vacated. So now they are proceeding again, Steve. Isn't it?
My lord, there was no order vacating, but simply it was withdrawn for liberty to refile. And immediately we file on 29th.
Immediately you filed or when did you file?
On 29th it was filed, registered on 2nd of December.
So you want that interim to be passed again?
My lord,
You want that interim protection again?
there is the prayer in my this petition, my lord. Kindly come to my prayer.
Now, why did you file two writ petitions?
This was, my lord, in terms of the 4/4/2024, that was challenged. In this, my lord, the earlier one was also on this, perhaps on the same ground. After filing of this earlier one, my lord, this one had to be filed because the order now impugned was not handed over to me. The 4/12/2024. That's why I filed this one.
So without this 4/12/2024,
Yes.
what have you challenged?
There is the order challenge now. And the entire proceeding, prayer, my lord, can come. Here it was in the earlier petition, my lord, which was withdrawn. Same prayer. Entire proceeding, the suspension order, then the charges of employment misconduct, 4/4/2024, appointment inquiry officer. Then, my lord,
So let notice go then. About the case.
Interim order may be given.
Miss, yes, what do you say?
The association was registered under the Trade Union Act. But they have not submitted the application for recognition as required. As required, my lord, recognition is necessary for the association.
Recognition by
Association, by the institute,
institute.
by the government institute. They have not submitted the memorandum of association and memorandum of article of.
We have already intimated, my lord, we'll submit it.
This is the procedure, my lord.
Central Civil Service.
Yes.
Is it applicable to them?
Yes, my lord.
Which paragraph? Which provision?
4 and 5. The condition for recognition. 5, my lord. Condition for service application with fulfills the following condition may be recognized by the government. Namely, such application for recognition of service association has been made to the government containing memorandum of association, constitution, bylaw of the association, name of office bearers, total membership, any other information as may be required. And BCD, that was. But it is clear from the letter at page 59 that
We'll examine this. We'll issue notice today.
Only interim order may be given as earlier.
my lord,
Otherwise, representative will
we
inform us.
have started the proceedings because service misconduct. Service misconduct means, my lord, they have superseding the institute. Directly submitted a legal notice to the ministry. Ministry directed to take action. And this is the
You file-
violation of.
You file your affidavit. We'll issue notice today. You file your affidavit.
In the meantime,
And
interim order, some
heard
protection.
Mr. R.P. Sharma, Learned Senior Counsel, assisted by Miss
Bora.
M. Bora for the petitioner. So by filing this writ petition, the petitioner has challenged the disciplinary proceeding drawn against him by the respondents on account of forming a trade union, is it? On account of forming of trade union, he cancelled it. Instead, you write LGBRIMH,
Yes, please.
Nurses Association. So according to the petitioner, the respondent authority is not
Competent, my lord, I have challenged the
competent to draw the disciplinary proceeding against the petitioner. And moreover, there is no such provision which mandates that prior permission has to be taken from the respondent authority
Under the
for forming of service association.
Trade Union Act, section 3.
So the learned senior counsel submits that the petitioner had earlier filed WPC number 2356/2024. But since the annexures have been jumbled up, the same was withdrawn.
Paragraphs, my lord, paragraphs are jumbled.
The paragraphs were jumbled up, and therefore the same was withdrawn by the petitioner
With liberty, my lord.
on 26/11/2024 with liberty to file afresh. Stop. Thereafter, the petitioner has filed the instant writ petition. That will be in WPC 6561, okay? 6561 of 2024.
And my lord, 6685
In view of above, issue notice of motion, returnable by 4 weeks. Mr.
AK Datta.
A.K. Datta, learned CGC, accepts notice
Sir,
of,
my standing council of LGBR.
sorry, learned standing council of
LGBRI MH. Tezpur.
LGBRI
MH.
MH Tezpur, accepts notice on behalf of
2-3. Accept 2-3.5.
2-3.
all the respondents except all the respondents except respondent numbers
1.
1. Respondent number 1, okay. Mr. K. Gogoi, learned CGC, accepts notice on behalf of respondent number 1. Petitioner to serve requisite extra copies of the writ petition to the learned councils appearing today. Then similar order in WPC number
6685.
6685. Okay, similar order. And only one line you'll add. Having regard to the fact that an interim order was passed by this court
On 3/5/2024.
on 3/5/2024 in the earlier writ petition, that is WPC number 2356 of 2024. The disciplinary proceedings drawn against the petitioner. In terms of the office order dated 4/12/2024 shall remain suspended till the next returnable date.
Oblige, deeply oblige.
List the matter again on
After 4 weeks. Oblige.
yes. We'll have it on 27th of January.
Right.
Here the
My lordship, I am Anganwadi helper. I was appointed in the year on 2/7/2007. And since 16/10/2020, I have been rendering my duties as Anganwadi worker. As per notification dated 4/3/2013, which I have annexed, page 19 is my
Page 19.
page 19. As per this notification, I shall be considered for promotion. I am entitled to be considered for promotion, my lordship. Point number 2 may be seen. Only those Anganwadi helpers shall be eligible for promotion under this scheme who have been in continuous service for a period of 10 years and above as Anganwadi helper against sanctioned Anganwadi center. So, my lordship, my appointment was on 2/7/2007 and 16/10/2020, I have been working as in charge of Anganwadi worker. So I have submitted representations, various representation I have submitted. One representation which I have annexed, annexure 5, standard form of application. Page 17 may be seen. Page 17 is the standard form of application.
Hmm.
Then page 18, annexure 6 is my representation. And thereafter also another representation, my lordship, I have filed, that is on page 23. But no decision has been taken, my lordship, that's why I am aggrieved.
No, see, let me take the instruction on the basis of this notification 2013, Lordship, because several things may happen, whether this notification has been acted upon or not. So let me get the instruction based on this notification. He's claiming on the basis of this notification of 2013. So let me guess, sir, what has been done after that? Whether that has been acted upon or not.
Acted upon means the notification.
Right, and entitled to be considered for promotion or for to the aforesaid vacant post of as per the notification dated so and so of 4/2013 issued by the Commissioner.
Is there any dispute regarding this notification?
Before, Lordship, I have appeared in similar types of matter. What happened, Lordship? They find some discrepancy in those some of the notification. Sometimes they cancel it. After cancel it, that is not known to the other petitioner. So they claim that by filing it.
So you want to find out whether this
what happened to this notification? Yes,
you want to find out whether this notification
has been acted upon or not.
Can be acted upon or not. Can be acted upon or not.
Can be acted upon.
If it can be acted upon, we can dispose it just now.
No, that I cannot.
But you're not sure.
No, I doesn't have any instruction at this stage, Lordship, in my hand.
Mr. C.K.S. Barua, Learned Counsel. Learned Government Advocate shall obtain instructions as to whether notification dated 4/3/2013 is in force as on date. Four 2013, I said, no? After that, you put bracket and extra 7. List again on
3 weeks, Lordship. Just after
Instruction 3 weeks. If it is notice, my lordship, 3 weeks, you can be.
anyways, it is going to come in the next year, Lordship. If you saw as a first week of 2025.
Mr. Barua, you be reasonable.
First week of 2025, Lordship.
Only to find out whether this notification is in force or not, you need 3 weeks.
No, because I have calculated
How?
this vacation also, Lordship, because there is from the last week also there is.
The respondents, you see, who are the respondents here? Who has issued it? Commissioner, Secretary, Social Welfare Department is only one phone call away. You cannot take 3 weeks time for that.
Pray for 10 days, Lordship. It is if the instruction come before the vacation, Lordship, then that is good. Otherwise, Lordship.
No, why do you require 10 days?
And
You don't have any phone. You don't have any staff.
They take up tomorrow, Lordship. I may telephone them. I can make a phone call, Lordship, but it has to be on record, Lordship, in black and white, Lordship, so that I
No,
can
no.
face it before the.
We are not saying that he's entitled, she's entitled. But she definitely will be entitled to be considered.
Considered. That is
If the notification is valid and applicable as on today. That much only.
And suppose.
There is no 100% guarantee that you consider and promote this petitioner.
Our prayer is also that we should be considered.
Only thing is that
Only
you have to
thing is
consider.
that there is notification, Lord, whether that exists or it does not exist, does not exist, then is the reasoning why it is not been acted upon.
We'll have it on Friday. You find out.
No, Lordship.
List again on Friday. Give the date.
Highly.
By this application, the petitioner who was selected for the post of village Pradhan in the district of Nagaon after due selection. The respondent number 5 has filed an appeal before the authorities, and for that reason, my lord, the matter is pending. He could not be taken over charge. And I mean informed, my lord, the
appellate authority has not taken up these matters, my lord, with urgency, and therefore the matters are pending.
The appeal is pending, Lordship, before the Director of Land Record and Survey. And his basic prayer is to dispose of the appeal expeditiously.
That is my
And
only
that
prayer.
is the also that direction may go, Lordship.
Where's the appeal here? Have you enclosed a copy of the appeal?
My respondent has filed the appeal. I am the selected person. So
For-
for that reason, I am not being appointed as a village pradhan.
Respondent number 5 has filed the appeal.
My lord, my lord.
When did he file?
He filed in the early part of 2024, my lord.
You don't have any details of the appeal?
I have the details, my lord. 7/12/23, it was filed before the secretary. Then it was referred to back to the proper authority, my lord, Director of Land Records. Earlier, he approached the Honorable Court, and there the Honorable Court has directed that the appeal should be disposed of within a period of 60 days.
There was a writ petition earlier filed by respondent number 5.
My lord, at page 20, 21. There also direction was given, and accordingly he filed the appeal, but the appeal is pending. Only on inquiry, my lord, I could take the notice about the appeal, my lord, knowing from the Commissioner Nagaon. So my only prayer is that there may not be any further delay and matters should be.
How much time will be reasonable? How much time will be reasonable?
3 months, no? 3 months, Lordship.
3 months.
If they have to serve the copy, that other person also, there is a several, the appeal has been pending. The same select list, same code. So many persons has been, those who are selected, I guess that that unselected person, they have been approved, preferred that appeal.
Grama Pradhan is only for
For particular lordships.
lot number 2.
Lot number 2. Here it is lot number
So-
2.
Select list,
We are concerned with that only.
Yes, we are concerned with that only.
So out there,
Only
there is
one appeal is there.
there is an appeal filed by this Rinkul Islam in the earlier writ petition.
My lord.
So let that be considered and disposed of within a time frame. By who's the authority?
TLR.
Director
Number 2.
Director of Land Records.
Director of Land Records.
Response number 2.
Let it be within a period of 2 weeks, 2 months, my lord.
You cook fast.
Earlier writ petition, that Director of Land Records was not a party, isn't it?
That was not.
That appeal was before the that GAD, General Administrative Department. Now that it has that.
Now this appellate authority has
Authority is
been fixed. So I made him a party.
You have been selected, Mr. Chaliha.
My lord.
You have been petition is selected.
Selected.
Heard Mr. D.P. Chaliha, learned senior counsel, assisted by Miss M. Roy for the petitioner. Also heard Mr. C.K.S. Barua, learned government advocate,
For 1, 3, and 4.
for respondent numbers 1, 3, and 4, and Mr. J. Hendy, learned counsel for respondent number 2. Stop. Having regard to the projection made by the petitioner, the writ petition is taken up for disposal at this stage. Stop. Next para. It is the case of the petitioner that he has been selected for appointment to the post of Grama Pradhan of lot number 2, Bawati,
Boruwati.
Borwati. Where do we get that?
Lordship,
Synopsis.
synopsis.
In a first line, my lord. Boruwati and Batawari village on lot number 2.
Baruwati
And Batawari
and Batabari village
in lot number 2.
in lot number 2 under Dhing Revenue Circle. Stop. However, the private respondent number 5 had earlier filed WPC number 4561 of 2023, claiming appointment to the said post. Stop. The writ petition was disposed of by order dated 11/8/2023. By directing the petitioner therein by uh, by directing
At page 23.
the principal secretary was directed to consider.
That time, I
But,
don't know how.
but today you're saying director of land records.
It is the earlier.
Secretary General Administration Department.
Oh.
Now, my lord, they are not taking the appeal.
There was a government decision, lordship, to transfer all the appeals to the revenue lordship to the, so they will decide the appeals.
Okay, but the direction was to the principal secretary here.
Even that period, my lord.
Earlier it was my lord GAD.
Earlier it was GAD.
Principal Secretary.
No, that has been transferred to the
Yes, yes,
director
the power has been transferred.
after the passing of this order.
My lord, my lord.
What did I say last line? You just before that, you just read the sentence. Appeal preferred by the petitioner therein be placed before the principal secretary to the government of Assam, General Administration Department, who shall dispose of the same by way of a speaking order within a period of 60 days from the date of receipt of a certified copy of the order. Stop. Since the said appeal has not been disposed of till date, the present petitioner contends that his appointment as Grama Pradhan has been kept on hold, and therefore prays that the appellate authority, who is the Director of Land Records and Survey, etc., Assam, what did I say? Who is now, no? Appellate authority, who is now Director of Land Records and Survey, etc., be directed to dispose of the pending appeal within a time frame. Time frame was already given. Again, now we're giving another time frame. How many times we'll give the time frame?
That left only.
Next para, having considered the limited prayer of the petitioner, the writ petition is disposed of with the direction to the respondent number 2, that is the Director of Land Records and Survey, etc., Assam, to consider and dispose of the appeal of the respondent number 5, if not already disposed within a period of 2 months from the date of receipt of a certified copy of this order. Writ petition stands disposed of.
Lordship, my lord, 1 to 2024. Yes, it, my lord, that
The
the
power
PLI
is-
power has been given to the.
And this judgment is of 23. So judgment is of 23 and the government notification is of 24.
1 to 2024.
That is fine, Lordship.
1 to 20.
24.
I said one line, na? Now, which is now the direct appellate authority.
Yes.
What did I say there? Sentence?
Email করে দাও। Photo website এ। Email হবে।
Appellate authority. What did I mention? Appellate authority. Director of Land Revenue. That sentence. No, no, before that, just read again. That what you just read, slightly from, little bit from before that. Just now you read appellate authority that you read, that sentence. Huh? Just a minute. Director, who is now Director of Land Records and Survey, etc., Assam. After that, you just include this. Since 1/2/2024. Yes.
May I please, Lordship?
Yes.
Lordship, the petitioner retired on the 31st of March 2022 from Assam Government Marketing Corporation as a peon cum night chowkidar. Since then, he has been approaching the respondent number 2 for releasing his leave encashment benefit and gratuity benefit, but the same has not been released.
Who will release?
I beg your pardon, Lordship.
Who is the authority to release it?
The respondent number 2, the managing director, Assam Government Marketing Corporation.
Anyone appearing for managing that?
My lord, this moment, I am appearing for respondent number 1, my lord.
Hmm.
Let notice go for to and fro, my lord. Similar writ petition is filed, my lord. Last week, my lord has issued notice.
Day before, yes.
The
day before similar writ petition.
Similar writ petitions were filed.
Okay. Heard, Mr.
B. Hazarika.
B. Hazarika, learned counsel for the petitioner, who submits that the petitioner is aggrieved with the action of the respondents in not releasing the retirement gratuity as well as balance amount of leave encashment to the petitioner. Issue notice returnable by 4 weeks. Notice of motion, huh? Returned by 4 weeks. Mr. Aadhar, learned State Council accepts notice on behalf of respondent number 1. Petitioner to serve notice to the respondent numbers 2 and 3 by registered post with ADD within 3 days. Petitioner shall serve requisite extra copies of the writ petition to Mr. Aadhar within 2 days.
Lordship, in this case, I have a limited prayer, Lordship, to dispose of my review petition on merit, Lordship, not on the technical ground, Lordship. Here, Lordship, what happened, may I take, Lordship?
Where is your review petition?
That review petition, Lordship, ordered that was page 86, Lordship.
This is an order, you said review petition. Where's your review?
Petition is there, Lordship. May I take, Lordship, the order first, Lordship, the appointment order, Lordship. That is on page 25, Lordship. He was selected as a Grama Pradhan, Lordship. and his that 25 lordship.
Yes.
Now lordship, he was selected as a 20 serial number lordship 23. That is on page 27 lordship. Will find his name, this petitioner name lordship.
Yes.
Then lordship, this his selection was challenged by the respondent number 4 lordship. That was on that lordship will find on page 38 lordship.
What is 38?
Page 38 is the lordship challenge the selection of this petitioner's appointment lordship by the respondent number 4 lordship.
This is an order.
Yes, lordship. This order for lordship is extra mark as he is a member of the ex-Grama Pradhan lordship. Now this order lordship, subsequently this petitioner selection was lordship revoked. That is on page 70 lordship, annexure 7 lordship.
No, please tell me what is this page 38? This is an order. You said it was challenged.
My selection was challenged by this this order lordship.
How?
The lordship that is reflect because
How does the order challenge your selection? Tell
Yes.
me.
It's a 15-7 order lordship.
Whatever it may be, what does the order say?
Order said on the lordship last part lordship. Then on page 39 lordship, perusal appeal petition such and such perusal on such and such passed by the deputy commissioner Sonitpur. Also peruse the parawise report dated 24/1/23 submitted by the deputy commissioner Lakhimpur. After considering all the available record paper furnished and argument put forward by the advocate of the petitioner, that is the respondent number 4's petition lordship advocate. Petitioner and the respondent in the event of no extra marks for the family member has been given to the appellant despite being family member of the ex-Grama Pradhan of the lot number 20 of Laluk, Viewporia Revenue Circle. Hence the order dated and passed by the deputy commissioner is set aside and quashed. The appointment authority is hereby directed to start process for selection of the Grama Pradhan lordship. Then this petitioner lordship approached before this honorable court lordship by filing writ petition, that is on page 41 lordship.
Who filed the writ petition?
This present petitioner lordship, Ramesh Bhuiya lordship.
Page?
Page 41 lordship. And relevant portion started from page 42 lordship.
Giving liberty to file review.
Yes, lordship. 90 days time has been given lordship to file review lordship. Accordingly, he has filed the review petition that is on page 62. lordship.
Review by the present petitioner.
Yes, lordship.
Page number?
62 lordship.
62.
That petition was filed lordship on 10/1/2024 lordship. Beyond 90 days lordship.
Filed by whom?
By this petitioner lordship.
Beyond 90 days.
Beyond 90 days lordship. The
That-
ground along with that lordship.
That means you filed belatedly.
Yes, lordship. Because of lordship element lordship, he could not file this review petition in time lordship. That lordship review petition lordship will find on page 62 lordship.
So what do you want now?
Now lordship, kindly come to the page 74 lordship, the order passed by the respondent 1 lordship. The decisions and order lordship. Bottom part lordship, decision and order lordship. Roman 4 is their lordship. However, this will not be a bar for submitting a properly reasoned application for condemnation of delay at any later date by the applicant if so advised. Accordingly, lordship, this petitioner filed a condemnation petition that is on page 76, lordship.
Then
Page 76 is the lordship condonation petition. Along with the page, kindly peruse the 84, page number 84, lordship. This is the medical certificate, lordship. He was suffering from malaria, lordship. That's why he could not file in time, lordship.
so it was not condoned.
No, lordship.
That's why you
Only
come.
14 days. Only 14 days delay, lordship.
So you come to this court
Yes, lordship.
after that.
Yes, lordship.
Yes. Okay. Mr. Andy, what to do? What do you say?
My lord, delay ground, my lord, that I cannot say anything because there is a, my lord, the provision, my lord, as per the provision, my lord, within the 90 days, my lord, they have to file this appeal.
But there's a provision for condoning the delay.
Condoning delay.
There's no
my lord,
bar.
There's
no bar.
no bar.
Only thing is that
Dispose of, my lord, that they give a direction to dispose of the appeal or review petition, my lord,
Yes,
in
lord.
accordance with the law, lord.
Yes, lordship.
Delaying the condonation.
please write down. Hard, Mr.
D. Chaudhary.
B. Chaudhary, learned counsel for the petitioner, and Mr. J. Hendrik, learned counsel appearing for the
For respond number one, one only.
respondent number one.
One.
And Mr.
But three,
C.K.S.
my learned friend.
Mr. C.K.S. Borough, learned counsel for respondent number 2 and 3. Stop having regard to the nature of the case projected by the petitioner. The writ petition is taken up for disposal at this stage. Stop next para. This is the second time the petition is before this court. Stop the earlier writ petition being WPC number 5690 of 2023. Was filed by the petitioner challenging the appellate order of the Divisional Commissioner, North Assam Division, dated 15/7/2023, passed in appeal number 40 of 2022. Please read the sentence, the earlier. Of the appeal was preferred by
Respondent number 4.
in this case.
Yes, Lord.
He's a party.
Yes, lordship.
Number.
Respondent number 4, lordship. Samuel Baral.
The instant respondent number 4, who was also respondent number 4 in the said writ petition. Challenging the appointment of the petitioner as Grama Pradhan. To stop the appeal was allowed by the appellate authority. By interfering with the appointment of the petitioner. And directing fresh selection for the said post, for filling up the said post. So the writ petition was disposed of by order dated 27/9/2023 by directing the petitioner to file a review petition before the divisional commissioner in terms of executive instruction, clause 162, capital D of the Assam Land and Revenue Regulations, 1886, within a period of 90 days. With a further direction that no, you cancel that with a further direction not required. Stop. Next para, the petitioner therefore filed his review petition, which however was time barred. And the respondent number,
Four.
Principal Secretary.
One lordship.
Respondent number 1, White, order dated 3/4/2024. Declined to entertain the review petition on merit, since this review was not filed within the prescribed period of 90 days. Stop. However, liberty was granted to the petitioner to submit an application for condonation of delay, if so advised. Stop. Though the petitioner submitted an application for condonation of delay, but the delay was not condoned. An order dated 19/9/2024 came to be passed. Stop. The learned counsel submits that the application for condonation of delay was not considered in the correct perspective, since it was on account of the medical condition of the petitioner, supported by a doctor's certificate, that he could not submit the review petition on time. To stop, he therefore submits that directed to consider the review petition of the petitioner on merit. Next, para, I have heard the submissions made by the learned counsels for the rival parties, and I have perused the materials available on record. The petitioner, by filing miscellaneous application, sought for condoning 14 days delay in filing the review petition. To stop, the reason for the delay was that the petitioner was suffering from hypertension, malaria, and type 2 diabetic and melena, and for which he had to undertake long-term treatment. Stop. Considering the grounds taken, this court is of the view that the delay of 14 days deserves to be condoned. So accordingly, the order dated 19/9/2024 is set aside, and the respondent number 1 shall consider the review petition filed by the petitioner as one to be filed on time, one to have been filed on time, and take a decision on merit within a period of
2 months.
2 months.
No,
2
they
months
have
from the
to
date
serve
of,
the notice to the private respondent.
Yes, that will.
So it will take time.
within the period of 2 months from the date of receipt of a certified copy of this order.
The
Full stop.
selection procedure, lordship, kindly be, that fresh selection procedure kindly be held, lordship.
Whether the advertisement was made or not, my lord, it is not in.
That advertisement is there. I have annexed that advertisement. This appointment advertisement I have given, subsequent appointment advertisement I have not found
Who's advertisement?
regarding the appointment of this petition.
My lord, they want to state my lord, this appointment, my lord, the selection procedure.
There is a direction to fresh selection, lordship. Because there is a direction.
Where?
That lordship order challenging that
Where?
on page 39, lordship. Page 39 bottom, the appointing authority is hereby directed to start the process of selection of Gaumura fresh.
It is further provided that the respondent number 1, in considering the review petition, shall give due opportunity to the respondent number 4 as well before taking a final decision. Stop till such decision is arrived at. The process of fresh selection, as has been directed by the order dated 17 July 2023. No, but this is long time back, 23 July.
23, because of that lordship,
What is the status today?
status today is lordship till they can say lordship. Now this they are going
If
to.
you don't know, then why do you pray for disposal at the motion stage like that?
Because lordship, they
Creating more
definitely have that
complication.
option to say, publish the lordship, go for selection on. Since there is a, it's open for them to,
See, we passed this direction now.
yes.
In the meantime, supposing there's already a fresh selection going on and it's going to be finalized, then
Subject to outcome this petition, lordship review petition.
why should we say that? You should at least come with all the facts, isn't it? All the information required. Third party will come and say that why have this stay order has been passed? I have not been heard.
And I'll leave it to lordship.
Then we'll cancel the order then.
Then I will, that review petition that can be considered.
Huh?
That review petition can be considered, that much lordship.
Okay, no observation. You're
Okay,
inviting more?
Otherwise, create a problem, lordship. See, lordship was stayed is the procedure. But let them complete the that procedure, my lord, review petition, my lord. Within that, my lord, that 2 months, lordship.
So that is there, no doubt. But why not an observation that no fresh selection to be done?
Lordship. My lord, till that the process has not been taken place, lordship.
Till the disposal of the review petition as directed in herein above, the respondent authority shall not go for fresh selection.
Highly obvious.
Yes.
Obvious, lordship.
Yes, 14.
Petitioner hearing, your lordship, is agreed by the notification issued by the office memorandum issued by the respondent number 3, your lordship, by which it has been decided that no fresh cases for completion and appointment will be considered, your lordship. While petitioner case is pending for consideration, your lordship, this notification has come, your lordship. So there are other similar.
You are telling the OM?
Yes, your lordship. There are other similar matters.
5067 of 24,
your lordship.
You want to connect with that case?
Yes.
Will issue notice?
Yes.
I heard Mr. K. Mira, learned counsel for the petitioner, submits that by filing this writ petition, the petitioner has challenged the office memorandum dated 18/9/2024, by which the petitioner has been deprived of the opportunity to be considered for compassionate appointment. Issue notice of motion returnable by 4 weeks. Miss
MM Kotoki,
M.M. Kotoki, learned
Standing Council, Animal Husbandry and Veterinary Department.
standing counsel A.H. and Betty, accepts notice on behalf of respondent numbers
1, 2,
5.
1, 2, 5.
1, 2, and 5. Mr. D. Bora, learned government advocate, accepts notice on behalf of the remaining respondents.
3 and 4.
1, not 1. State of Assam.
Secretary, Veterinary Department.
Oh, that, of course. 3 and 4, sorry. Respondent number 3 and 4. Petitioner to serve requisite extra copies of the writ petition to the learned counsels appearing today. List the matter again after 4 weeks, along with WPC number 5067 of 2024. 5067. Yes.
In this matter, I was selected to the Assam Police Service pursuant to a selection by the APSC. My lord. Thereafter, my lord, there was
You selected to
the Assam Police Service Junior Grade.
Assam Police Service.
Assam Police.
Okay. Then?
My lord, thereafter, there was an FIR lodged alleging some irregularities in the APSC conducted selection processes. My lord, the FIR was registered, certain charge sheets were filed. A one-man commission of inquiry was appointed by the government with the Honorable Mr. Justice P.K. Sharma as the chairman of the committee. That committee, my lord, examined the issue and my lord found that my marks in the tabulation sheets had been increased. So therefore, my lord was of the opinion, but this was without giving me any opportunity of hearing, though I'm not challenging that 8B, 8B8C, my lord, of the Commission of Inquiries Act. But my lord, without giving me any opportunity of hearing under 8C, my lord, this observation was made. On the basis of that observation, my lord, I have been suspended and a show cause notice has been issued, initiating departmental proceedings against me, my lord. My lord, I am challenging the continuation of the departmental proceedings. Lordship, when, my lord, the criminal proceedings are pending, my lord, now a charge sheet has been filed. This is the 14th charge sheet. It's supplementary charge sheet number 13, wherein, my lord, I have been implicated as accused number 12. The criminal proceedings and the department proceedings are based on the same set of facts, my lord, the same witnesses say.
This is that same case.
Same
Yes,
case.
sir. What was the order passed?
My lord, certain orders have been passed by lordship.
Stay order was passed.
Yes, my lord.
Stay till returnable date.
Fine.
Third, Mr. P.D. Nair, learned counsel for the petitioner, who submits that the grievance of the petitioner is that simultaneous proceeding has been initiated against the petitioner. One under the criminal proceedings and one under the one department and the other departmentally. To stop, the learned counsel submits that the origin of the proceedings is due to the one-man inquiry commission report submitted, in which the petitioner did not have any opportunity to present his case. Stop. He submits that since the departmental proceeding has been initiated on the same set of facts and with the same set of witnesses as that of the criminal proceedings, the departmental proceedings pending finalization of the criminal proceedings be stayed. Stop. He submits that in similar other case, which was also a result of the one-man inquiry commission report, this court had given protection to the petitioner by staying the departmental proceeding as an interim measure. Stop. In this connection, he refers to the order passed on 4/12/2024 in WPC number 6411 of 2024. Next, in view of above, issue notice of motion to turn over by 4 weeks. Mr. C.K.S. Barwal, government advocate, accepts notice on behalf of
1 to 6.
respondent numbers 1 to 6.
7 is easy.
7 is
Accountant. Accountant. Standing counsel easy.
Miss Mr. P. Chakravarti, Learned Standing Counsel, Accountant General, Assam, accepts notice on behalf of respondent number 7. Petitioner to serve requisite extra copies of the petition to the learned counsels appearing today. Next, by having regard to the projection made by the petitioner, in the interim, it has hereby provided that the pending departmental proceedings against the petitioner shall remain state. Till the next returnable date.
Deeply obliged.
Your Lordship, matter relates to the petitioner selection and appointment for the post of driver.
Biswas, just tap the microphone whether it's working or not.
It's working.
Just tap it.
It's on.
Oh, it's coming. Yes, what is your case?
Matter relates to the selection and appointment of the petitioner as the driver in the office of the CGM, Mankachar, Harshingmani. Matter the advertisement date, please come to Annexure 4, advertisement dated 20/05/2022. Annexure 4, matter. Annexure 4, page 18, my lord.
Yes,
Driver.
what is this?
Then, my lord, interview was held, my lord, and selection, my lord. Several drivers has appeared interview, my lord. Now, my lord, there was, your lordship will find, my lord, kindly observe that there is no mark system, how the mark will be counted. Out of what marks will be given, your lordship will not found. In the advertisement, please come to my lord, para 11, my lord, kindly come, page 20, para 11. The candidates applying for the post of driver shall have to appear in a driving test to be conducted by the District Transport Authority, South Salmora, Mankachar, and Bhaivavasi. Then, my lord, similarly situated cases, page 23, what our High Court has done for the post of driver, my lord. Kindly come to page 24, my lord. Driver selection process, that is screening test 40 marks. Then driving test 40 marks. Bhaivavasti 20 marks, that's 100. But in the case of this Mankachar's interview, there is no such division of marks out of what is to pay. Then, my lord, in a similar, another case I take your lordship, page 25, Majuli, CGM Majuli. Here also your lordship will find there is a separation of the marks, my lord, how to apply, my lord, page 26, your lordship will get. The applicant must subscribe application for the post of driver. Then, my lord, page 27, the candidates who qualify to skill test will be called for the Bhaivavasi test 30 marks. Only 30 marks Bhaivavasi. Now, in our case, my lord, your lordship will find by that.
Your synopsis says that.
Beg your pardon.
Your synopsis.
I was not selected, madam.
No, please listen.
Yes.
In your synopsis to the writ petition,
Yes, madam.
you written that screening test is 30 marks.
Yes.
Driving test is 70 marks.
I got my.
Viva voice is 60 marks.
Yes.
Total how much?
Total, my lord, 160.
150.
Yes.
Total marks is 150.
60.
Page 29.
Page 29, you lordship will get.
Okay, 160.
Page 29, man. Kindly come. Annexure 6. Total mark 160. Stop, my lord.
So what is wrong in this? What is wrong in
Yes,
the,
what is wrong? But my lord, in other case, our High Court as well as the Majuli CJM, they have made the specific marks regarding screening test and other marks. But what is the total marks, my lord? Now, in this case, my lord, I secured, my lord, 45 in the driving test and screening test 25. And my lord, when Bhaibhavasi has come, I got 20 marks. Whereas the private respondent, he got 30 marks in driving test, 10 marks in screening test, and 55 in the Bhaibhavasi. My lord, in the Bhaibhavasi, what I was told by my client, there was only 2 questions to verify the driving license and experience, as well as name, father's name. He got 55 marks. In other 2, my lord, he did not get. So, my lord, that's why I have come before your lordship, my lord. Kindly call for the records and meanwhile to stay the further selection, my lord.
Look, my submission is that so far as the contention of the petitioner is concerned with regard to non-mentioning of marks or criteria in the advertisement is concerned, that will not vitiate the selection process. And it is an admitted factual position before your lordships from page 29 that this private respondents has got more marks than the petitioner. He scored 95 and 90. And no mala fide has been alleged here in the writ petition. So, under what records will reveal that why 55 and why 20. But lordship may be pleased to issue notice, but I don't think there is any case for stay of the proceeding is made out. Already, Milord, perhaps this select list
not yet appointed.
On 5/12/24, the select list was issued. Page 30.
Yes, yes.
So apparently on the face of the records, the respondent, that is serial number 3, he has got more marks. And your lordships is aware that the selection committee enjoys certain laxity with regard to manner and method of conducting the selection. So in that view of the matter, my lord, in my respectful submission, my lord,
there is no division of the marks.
Division of the marks. There's no division.
There's no division of
No,
marks, isn't it?
That's how 60 he got 55.
No, just a minute, Mr. Biswas. Don't get excited when I ask him question.
Yes,
Let him answer.
yes.
See, marks obtained in driving test,
30.
30.
Out
Now,
of 50, 30.
What is the upper limit?
Out of 50. It is petitioner's contention, the driving test 50 marks, signal test 50 marks, and Viva Bose 60 marks.
We have been
Total
told like
160.
that. We have been told like that. That's why I could write.
No, it's
Total 160 mark that your lordship will find page 29, total marks.
Just repeat again. 50.
Yes.
50?
50 in driving test,
Yes. Then,
50 in signal test,
okay.
and 60 mark in Viva Bose, and in the last column your
50,
lordship,
50, 60.
50, 50, 60. Total in the last column your lordship will find 160 marks.
160.
So, admittedly, my lord, on the face of the records, the private respondent has got more marks than the petitioner, my lord.
Out of 50, he gets only 10 marks for traffic signal.
Yes, traffic. That is the very main thing for driver.
How will he drive?
And my lord, yes. And my lord, driving test, he got 30 marks.
For him,
Because
signal
I got
does not.
45 marks.
It appears that for him, signal doesn't mean anything.
My lord,
Yes.
what I am submitting is that lordship will definitely consider the records and
You
come
get
to
the
a-
records, don't proceed.
But the thing is
When
that,
can you proceed? When can you produce?
Lord, I need to take instruction, my lord.
That's why we'll give you time. By
Yes.
what? By which time can you produce the records?
South Salmara. Monday or Tuesday, my lord.
Hmm.
Next Monday or Tuesday.
Tuesday.
But my only prayer before your lordship, since it's a post of driver
Hmm.
and it's the only post, if there is any interim intervention by this honorable, perhaps that will cause difficulty.
No, you don't,
Lordship will keep it subject to the outcome, may not be inclined to pass the interim order. My humble prayer before your Lordship.
But to my information, my lord, a
Because-
private driver
Because
is
why I'm saying
working
so,
already. They want to
whether-
regularize one driver.
Whether 55 mark granted to the private respondent is excessive or not, that is a debatable issue. That can only be decided after filing of affidavit and consultation of
Alright, you
records
file
by
your
your
affidavit.
lordships.
I have got no objection.
So,
Till that, no
since it's
finalization.
a issue to be decided, after hearing the parties.
okay, now you tell me,
Yes,
in such kind of interview or selection,
yes.
are there more than one or two in the panel?
Three, the members are there.
3 members.
3 members are there. So 3 members sitting together, decided no malafide has been alleged that so and so member was influenced or so and so was
Okay, 3
there is
members.
some.
Yes.
So that's why he has given more marks
Hmm.
in Viva Bose. Nothing such has been alleged. So that's why, I am praying, Lordship will decide the entire issue finally. May not be inclined to pass since it's a post of driver.
My lord, my submission is that unless your lordship give a protection, my lord, then my lord, ultimately it will have,
What kind of protection?
not to finalize the matter.
No, supposing it is finalized and you are being able to make out a case, then this person will go.
Yes.
Same thing.
Lordship will
Even
keep subject to the outcome.
For short date, my lord, if they can produce the records, my lord, if your lord satisfied, then your lordship can proceed also, my lord.
The
think
problem
there
is
will be no
I
bar.
can produce the records.
But
No
they have
problem.
got a driver. This district is running since long. They have got a driver. They are working with the driver. They want to have a permanent driver.
Where is your statement?
That is not the, but.
Then?
No, without driver, how
You say
CJM
anything and court will obey. Court will listen to you.
CJM is working, my lord.
Mr. Biswas, you must have something on the pleadings to back up your submission also. If you have not mentioned, you cannot keep on adding new facts by mentioning it like that verbally.
But my lord, your lordship will
Heard
take-
Mr. S.C. Biswas, learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner has challenged the illegality and arbitrary action on the part of the selection committee who selected selection committee for appointment to the post of driver under the establishment of Chief Judicial Magistrate, South Salmara, Mankachar. Stop. Referring to the final compilation of the mark sheet, the learned counsel submits that the private respondent number 6 has been surprisingly given very high marks in the Viva Voce test compared to all other candidates, including the petitioner. To stop. He submits that in fact, the respondent number 6 had only obtained 10 marks in the traffic signal test, while 30 marks in the driving test, compared to 25 marks and 45 marks respectively secured by the petitioner. Next para, in view of above, issue notice of motion returnable by we'll make it returnable next week.
Fine, my lord. I can produce the records. But perhaps
Returnable.
if your lordships issue notice, keep the entire thing subject to the outcome of the writ petition. And I'll also file affidavit, the private respondent, he also has to be heard. Whatever decisions come from your
Absolutely, yes,
lordships.
we also appreciate, my lord. That's why not to finalize the matter.
Returnable by what do you call? 17th of December 2024.
My lord.
Mr.
H.K. Das. my lord.
H.K. Das, Learned Standing Counsel,
Yes.
Guwahati High Court, accepts notice on behalf of all the respondents.
No, my lord. 2, 3, 4, and 5.
Oh, who are the respondents?
My lord. One is state.
Yes.
on behalf of respondents 2, 3, 4, and 5.
Yes.
Correct?
Yes,
Mr. C.K.S. Barwal, and government advocate, accept notice on behalf of respondent number 1. Notice is therefore complete. Petitioner to serve requisite extra copies of the writ petition to the learned counsels appearing today. Learned standing counsel to produce the records
of selection.
of the selection
Yes,
on Tuesday next.
yes.
Regarding notice upon respond number 6, my lord.
Respond number 6, my lord. Notice
Okay.
has to go.
Petitioner to take steps for service of notice upon respondent number 6 by registered post with AD.
And by speed post, I'll take tomorrow. Speed post, otherwise it will take long time.
Registered post.
Registered speed post. Actually.
Registered post. If you want speed post, you do speed post. Well, I'll say registered post.
My lord, my prayer not to finalize the matter. Till that, my lord.
Till the next date of listing, the further process. Till the next date of listing, the selection to the post in question shall not be finalized.
But subject to correction, my lord, selection has already been finalized since select list has been published. Lordship will keep it subject to the outcome of the
No,
petition,
not to
because
finalize the appointment.
this will
That is-
entirely has to be decided by your lordship, my lord. So it's a post of driver, and this is a newly
Driver
established.
who doesn't know the signal,
Lord,
he got a 10 marks in
one
signal,
second,
my lord.
my lord, this is the newly established judicial district, my lord.
No, not newly, brother. I think
South-
you are
South-
subject to correction.
Mankachar.
Mankachar, I know how.
No, South Salmara, sir.
Yes, Mankachar South Salwa already 5
So
years.
perhaps that will cause inconvenience. So that's why lordship will keep
My lord,
subject to the outcome of
Please
the.
write till the next returnable date. No further steps shall be taken by the respondents to fill up the post in question.
Obliged.
However, the same shall be subject to reconsideration on the returnable date
Obliged.
on the basis of after perusal of the records. Yes.
Highly.
May it please your lordship.
Yes.
My lord, I'm inviting my lord's attention to page 13, 1-3.
13. Yes.
1-3. At serial number 4, my name is there.
Okay.
My name is Mr. Govind Burman. I'm a skilled work assistant under the Central Water Commission, my lord. They're transferring me, lordship is there.
Yes.
They're transferring me to the Tooting site, that's in Arunachal Pradesh, you know. The division is different, it's in Arunachal Pradesh. I'm precisely assailing this order of transfer. The first and foremost, you know, I requested the authorities by representation at page 17.
Have you made the serial number 5 a party?
No, I am willing to go for transfer. It's not.
Oh,
that
you're
I-
willing to go?
Willing to go for transfer.
Then why did you file this petition?
Page 17, my lord, my representation. I offered. May I read that, my lord? With due respect, I would like to state that I, Govinda Burman, so and so, got selected for a new posting place at Tooting under so and so. In this regard, I am writing this application to request you kindly to change my place of posting at any site under Puthimari Pagladia subdivision, Nalbari, in the Middle Brahmaputra division. The main reasons behind the same are: A, I'll retire on 29 February 28, so that I remain only 3 years and 2 months in active service. My wife, Padumani Burman, is psychiatric since 3 years, and doctors advise check up mental condition regularly after 2 months. In this regard, required prescription of so and so attached for every reference. I have 2 children, 1 son and daughter. My daughter is married since 4 years at Nalbari. My son is studying BA 3rd year at Nalbari College, Nalbari, so that I am the only member to take care of him. I request you kindly to consider the same. I shall be highly obliged for your response. So I offered them a place at Nalbari. If you wish to transfer me, can you transfer me to Nalbari division?
But you said you agreed to go.
No, this one. I did not say you keep me at Guwahati. You may transfer me certainly, but kindly consider my prayer at page
But
17.
not in Tooting.
Not Tooting, that's too far away. And considering, my lord, that I'm on the fag end of my retirement, and there's a policy of the Central Water Commission, my lord. If I just-
Why don't you annex that in your writ petition?
No, that's what I got the law. when I scouted it, my lord, I could get it, I just place it on record, my lord, for a consideration, my lord.
This should have been part of your
No,
writ
no,
petition.
I'm not against the transfer. I say kindly consider at a place different than that.
I understand that.
I understand.
What I'm saying is this policy which you are having, you should have annexed it.
We could get it later, my lord. We could get it later. I stand corrected. If my lord takes up, this is, my lord, Group C and Group B. I'm a Group C person, my lord. I'd request my lord to come to the third page at clause 3. Clause 4. Clause 4. Clause 4 is, while transferring personnel from one station to another, the following aspects will be kept in view. I skip it for a moment. I invite my lord's attention to clause 6. 6 is on the part of the superannuation part. That's how they should process the consideration. Employees due for retirement on superannuation within a period of 2 to 3 years before their superannuation shall ordinarily not be transferred if persons of lesser age are available for manning the post. I still say I am not against the transfer, but not at totally. At Nalbari, I give my grounds for that.
You have three years.
I have 3 years.
This talks about 2 years.
No, 2 to 3 years. 2 to 3
Okay,
years.
2 to 3 years.
3 years. So there can be a favorable consideration. Of course, it's not in the exigencies of administrative service. They are transferring me as a routine transfer. Place me at Nalbari, fair old man, fag end of service. That consideration of page 17 is all I seek for, my lord. I'm certainly not against anyone. I'm not blocking the route transfer. The loop is intact. Nothing remains.
To facilitate such consideration, where is your application?
Page 17, my lord.
Since when did you submit?
I submitted that, my lord, on
4/12.
4th of December 24.
Before
the executive engineer.
and who's the authority to transfer you?
My lord. Same.
Same means?
The order has been issued at page 14 by the assistant executive
This
engineer.
is from the ministry.
My lordship.
This is from the ministry.
No.
Who has issued the order?
This is issued by at page 14. Assistant executive engineer, my lord.
No, the consideration of transfers is by the executive engineer.
They issue the order. There would be a placement committee who would, in a routine manner, post transfer persons from A, B, C, D.
Ah.
What I am saying is that since I'm in the fag end of retirement in the central water.
No, that I've got it.
That's what.
The placement committee.
Placement committee, they may consider.
Who are
because
they? Who are they?
but
Composition?
it should go from here because the authority
Because
issuing the office order.
you have written to the executive engineer.
My lord, because the order was issued.
He on his own cannot consider that.
Consider, place for consideration.
Exactly, that's why.
I cannot write to the committee, my lord. I have to write to the one who issues the order. And the highest authority in that
You are there
regard
for the,
would be the executive engineer.
what do you say?
Lordship, at this, I have to obtain instruction. Hague end of his career, he has plus 3 years.
Hmm.
So that cannot be. And if there is whether there is availability of any post or something, those things has to be considered.
Hmm.
At least 3+ years he has.
So you take instructions.
Lordship.
By which date?
18 Lordship.
18. That is Tuesday. No, it's Wednesday.
Wednesday, next
Wednesday. Wednesday. Where are you now?
What?
Still in Guwahati. Till then, you let him remain in Guwahati. Till 18th.
Movement already. No?
Movement order not yet issued, Lordship.
So that's for me, lord.
That's why.
That's why. Precisely.
That's why he just wants consideration. That's all.
I'm so grateful, my lord.
You may consider it and you may reject it also. It's all up to you.
We may take a decision on
You
his
can take a decision, but keep in mind the policy here. So you just take instructions and we'll proceed thereafter. I heard Mr. S. Banik, learned counsel for the petitioner, who submits that the petitioner has been transferred from Mechanical Subdivision CW Guwahati to shooting site under Upper Brahmaputra Division. White office order dated 3/12/2024. bracket Annex A, page 13, okay? So he submits that the petitioner has roughly 3 years of active service left, and since the new place of posting would put him in a very disadvantaged position, considering the family issues of the petitioner, the petitioner submitted a request for change of posting
Well,
to the respondent number 3 on
412.
4/12/2024, bracket Annexure B, which however has not been considered till date. And therefore, petition is before this court. Stop. Mr. S. Banik, Learned Counsel submits that. The request made by the petitioner for reconsideration of his transfer to any other place is also supported by the transfer policy applicable to Group B and C personnel of the ministerial cadre of subordinate offices of Central Water Commission. Stop. He therefore submits that the respondent authority concerned may be directed to consider his representation. Until such consideration is done, the petitioner may be given some protection. Next para, considering the above projection, let notice of motion be issued, returnable by 18th of December 2024. Ms. B. Sharma, Lanet CGC, accepts notice on behalf of all the respondents.
One more thing, Lordship, present transfer law is that one has to join. If transferred, then he has to make a representation. That is the present
You produce that on 18. We'll
Lordship.
consider along with whatever instruction you have. For all the respondents, petitioner to serve requisite extra copies of the writ petition to the Lanet CGC within 2 days. Stop. List the matter again on 18th December 2024. Until the next date, the impugned transfer order issued by office order dated 3/12/2024, insofar as the petition is concerned, shall not be given effect to. Lanet CGC to obtain necessary instructions in the matter. And also, that is up to you. You produce that.
Which one? Bless. May it please, Your Lordship. Your Lordship, the present writ petition is a sale is filed sailing the transfer order that is 6/12/2024.
Now you are this side.
This side, Your Lordship. I'm for the petition.
You are this side for which department?
Government, Your Lord.
Government.
of Assam.
This is not against government.
No, this is against the Union of India.
Okay.
Your Lordship, this particular present writ petition is a case of frequent transfer.
Case of
Frequent transfer.
frequent transfer.
Frequent. Your Lordship, what has happened?
Hmm.
If Your Lordship may kindly come to page number 18, Annexure 1. The petitioner is presently working as a officer commanding of a RCC. Basically, he joined the particular office of the project engineer, of the chief engineer, Project Brahman in Pasighat on 13th of February upon his repatriation upon completion of his deputation period in Chhattisgarh. Your Lordship may kindly note the dates here because it has got a bearing in this particular case. Here, on 13th of February, he joined this office, the office of the Chief Engineer, Project Brahmank in Pasighat, Arunachal Pradesh. Thereafter,
Office of the
Chief Engineer, Project Brahmank. HQ CE within brackets P Brahmank.
what is this date of TORS?
Date of
Serial number 8.
Yes,
TORS
that
means
is the date of basically joining that particular.
TORS full form.
TORS, that I am not aware, Your Lordship. But 13th of February, he joined this particular TORS.
Date of TOS, then date of TORS.
Transfer out of station and transfer to reporting station most probably. That is what I can.
Okay.
So he joined on 13th of February. That is not under dispute, Your Lordship.
So
Next page.
this is a joining report.
Yes, Your Lordship. Arrival report of the petition.
Okay.
That has been issued by the office of the respondent number 4, where he joined first upon completion of his repatriation to his parent department. Next page, Your Lordship, Annexure 2, page 19. 8 April, after 2 months, he was transferred. Next page, page number 20, at serial number Roman P. That is a petitioner. He was transferred from headquarters CE Project Brahman to 92 RCC. That is at Thumbin in Arunachal Pradesh, which is where he is right now presently posted. He is officiating this particular post as officer commanding. It's a command tenure post. Basically, the command tenure post envisages, Your Lordship, prior to being promoted to the next higher rank, he should have command experience. So he accepted this. Within 2 months, he was transferred. He accepted this particular thing because it is a command tenure posting, and he has got no issue with regards to this particular posting, even though it is a case of frequent transfer. He accepted it. Thereafter, he joined this particular post as officer commanding on 13th of May, Lordship. This, Your Lordship, will find in the moment order, in the arrival report at page number 26, Annexure 7. No, 9th of May, Your Lordship. At Annexure 7, page 26.
Yes.
He has been serving as officer commanding in that particular post since 9th of May 2024. Immediately thereafter, page 27 is the interpune order, Annexure 8. That is 6 December 2024. Now, after 5 months, 6 months, Your Lordship, he has been posted out again from Thumbin, Arunachal Pradesh to Aizawl in Mizoram. To project a different project altogether. The Lordship will find the name at serial number B, name of the petitioner.
Project Pushpak.
Project Pushpak in Aizawl. Your Lordship, I have annexed the transfer policy in this regard. Transfer policy earlier was of 1999 and that got.
This is a good posting.
Your Lordship, it is not regarding posting. It's a command tenure posting, Your Lordship. That I had actually stated in my
posted as what?
Officer commanding of 92 RCC. It's a road construction company. RCC means road construction company. He's of the rank of executive engineer.
No, he's in 92 RCC is in which place?
Kumbin, Arunachal Pradesh.
Kumbin.
Kumbin. Here, if I may take your lordship to page number 28,
Hmm.
the transfer policy in this regard.
Yes.
Under serial number 6, under the heading guidelines, the following guidelines will generally be followed. Serial number B, qualifications and suitability will decide an executive or staff tenure, though it will be endeavored to give all civil and E&M cadre officers at least one executive tenure at the executive engineer level and SE level, that is the superintendent engineer level. Next page, your lordship. Executive tenures will generally be of 2 to 3 years for officers of the rank of EE or equivalent and above, for commanding RCCs, BCCs, forward workshop companies, supply and task force and projects. So the petitioner, he is commanding a RCC. So minimum tenure generally should be 2 to 3 years. That was the policy. It subsequently got amended to 2 years, which is at page number 33, Annexure 11. I'll come to that, your lordship. Then, your lordship, I kindly come to serial number 3E. The above 10 years are subject to the following. Serial number 1, executive tenures may be curtailed, extended or curtailed based on organizational requirements or on performance of the officer. Curtailment of tenure would be on specific recommendations of project chief engineers, CEs, duly supported with specific instances and details of performance counseling, supported by suitable remarks in ACR, which has not happened here, your lordship. No kind of reason as such is mentioned, apart from a very vague or general term, organizational interest. That will not stand the scrutiny of law, in my most humble submission, your lordship. Here, the amended, I will take your lordship now to the amended posting policy, which is at Annexure 11, page 33, which is dated 18th of August 2023, which is the policy in vogue at present. Here, if I may take your lordship to serial number 2 of that amended Annexure 11, page 33, wherein this executive tenure was amended and it will be generally for 2 years. Two to 3 years, your lordship. For guideline 6C, this was amended. Executive tenures will generally be for 2 to 3 years for officers of the rank of EE or equivalent and above, commanding RCCs, task force and projects. Next para, para 6E, which is there in the earlier posting policy, it again got amended. Executive tenure may be extended or curtailed based on organizational requirements or on non-performance of the officer. Here I am presuming that it is not the case of the non-performance of the officer, because there will be counseling, there will be remarks in the ACR, which has not happened in the case of the petitioner. So I am assuming that this will be in organizational interest. Now, your lordship, in the Honorable Supreme Court, as well as this Honorable Court, as well as a judgment which actually fell down from your lordship in Bhavesh Hazarika, your lordship has stated that simply by citing organizational requirements will not suffice. Reasons has to be given. If no reasons are given in the impugn order, then that would be treated as bad in law. And that has been stated by our Honorable Supreme Court in the AP Royappa case. And more particularly and more recently, with regards to frequent transfer, your lordship, in one judgment of T.R. Subramanian. I'll place that judgment also for your lordship reference. Now, your lordship, at para 6EI, executive tenure may be extended or curtailed based on organizational requirements. But this organizational requirements would require reasons, which in the impugn order at page number 27, your lordship, is missing. Simply on the ground that the following posting has been approved in the organizational interest. Now, if I may place one judgment, two judgments of the Honorable Supreme Court in this regard, with regard to frequent transfer, as to how it affects the morale as well as the quality of work of the officer concerned. First is a case of B. Varada Rao, AI 1986 SC 1955. And there I may take your lordship to para number 5 and 6. Para number 5 at the bottom, quoting E.P. Roepa. I'd just like to read out for my lordship's consideration. It is an accepted principle that in public service, transfer is an incidence of service. It is also an implied condition of service, and appointing authority has wide discretion in the matter. The government is the best judge to decide how to distribute and utilize the services of its employees. However, this power must be exercised honestly, bona fide, and reasonably. It should be exercised in public interest. If the exercise of power is based on extraneous considerations or for achieving an alien purpose or an oblique motive, it would amount to malafide and colorable exercise of power. Frequent transfers without sufficient reasons to justify such transfers cannot be held as malafide. I stress my argument on this particular line. A transfer is malafide when it is not made for professed purpose, such as in normal course or in public or administrative interest or in exigencies of service, but for other purpose than to accommodate another person for undisclosed reasons. Now, if I may take your lordship to para number 6, which is very important. One cannot but deprecate that frequent, unscheduled, and unreasonable transfers can uproot a family, cause irreparable harm to a government servant, and drive him to desperation, which is the case in the present case also. It disrupts the education of the children and leads to numerous other complications and problems and results in hardship and demoralization. It therefore follows that the policy of transfer should be reasonable and fair and should apply to everybody equally. But at the same time, it cannot be forgotten that for so far as superior or more responsible posts are concerned, continued posting at one station or in one department of the government is not conducive to good administration, which will not apply in my case. It creates vested interest, and therefore we find that even from the British times, the general policy has been to restrict the period of posting for a definite period. We wish to add that the position of Class 3 and Class 4 employees stand on a different footing. We trust that the government will keep these considerations in view while making an order of transfer. This particular judgment has followed in the next judgment, which I have laid before your lordship, of 2013, in the case of 2008, your lordship. I'm sorry, your lordship. TSR Subramaniam. The citation is here, your lordship. 2013-15 SCC 732. 2013-15 SCC 732. Therein at para number 30 and 31, guidelines were laid down with regards to frequent transfer and why it should not be exercised. To para number 30. We notice at present the civil servants are not having stability of tenure, particularly in the state governments where transfers and postings are made frequently at the whims and fancies of the executive head for political and other considerations and not in public interest. The necessity of minimum tenure has been endorsed and implemented by the union government. In fact, we notice almost 13 states have accepted the necessity of a minimum tenure for civil servants. Fixed minimum tenure would not only enable the civil servants to achieve their professional targets, but also help them to function as effective instruments of public policy. Repeated shuffling or transfer of the officers is deleterious to good governance. Minimum assured service tenure ensures efficient service delivery and also increased efficiency. They can also prioritize various social and economic measures intended to implement of the poor and marginalized sections of society. We therefore direct the union state governments and union territories to issue appropriate direction to secure providing of minimum tenure of service to various civil servants within a period of 3 months. So this minimum tenure was actually a fallout of the Supreme Court guidelines, Your Lordship. Now, at this stage, Your Lordship, I only want a stay of this impugn order. Let them produce the records as well as file an affidavit as to what is the reason for my transfer, because they could not actually justify it in the impugn order. Even then also, Mohinder Gill comes to my rescue because the reasons has to be mentioned in the impugn order itself, which is not there.
The lordship has to decide to issue here lordship, whether he can be transferred. Lordship, whether his transfer can be treated as a frequent transfer or not, or lordship, whether guidelines, the minimum tenure which was given by the guidelines is a stated form or not, whether we can transfer it or not, lordship. As because my friend has already said that when he was posting the project Brahman lordship, and later on he has transferred to the other places lordship, he has no objection at the relevant point of time. Up to lordship is ব্যবস্থা হয়েছে page 26 lordship. Up to annexure 7 lordship regarding that place of posting in 92 lordship, 99 FPO lordship, he has no objection, he has accepted lordship. Now basically he challenged the page 27 lordship, annexure 8. So lordship, my let me kindly come to page 27 lordship, annexure 8. Posting transfer of grip officers lordship. Then lordship that's probably second line page is not lordship eligible. Otherwise, the following postings have been approved in the organizational interest. My lord, may kindly mark it. The transfer was done lordship.
Where is that? Which you
It
just
is
said?
lordship page 27 lordship. And below lordship transfer of the grip officer, that underlined portion lordship, it is not eligible lordship. Above lordship, that first page 27 lordship. Page 27 lordship.
27 is annexure 8.
Annexure 8 lordship.
The original copy or the typed copy?
Type petition.
Type copy.
27 and 27A.
Type copy probably type copy has not provided to me lordship. Otherwise, my lord may kindly peruse the following postings have been empowered in the organizational interest. Lordship got it?
Yes.
My lord may kindly mark it. It's for organizational interest lordship. Then lordship, the transfer policy which was relied by my friend lordship, it is in page 28 lordship. Guidelines 6 lordship.
Yes.
The following guidelines will generally be followed lordship. A, organizational functional requirements will be overriding consideration for posting. My lord may kindly mark it.
Which one?
6A lordship. 6A lordship, organizational and functional requirement will be the overriding consideration for posting. Here lordship, the transfer was lordship done for organizational purpose, organizational interest lordship. The transfer itself speaks that lordship, organizational interest lordship. Six A lordship. Organizational and functional requirements will be overriding consideration for posting lordship. My lord, kindly mark. Lordship got it? 6A lordship.
6A.
6A lordship. Guidelines 6A lordship.
Yes.
Then my lord may kindly come to next page lordship, page 29 lordship. E lordship. Is no modification? E Roman 1 lordship. The executive tenure may be extended lordship. Then lordship, cartel based on the organizational requirement. My lord may kindly mark it. Or on the performance of the officer. Curtailment of tenure would be on specific recommendation of the project chief or engineer, duly supported with specific instances of details performance and counseling supported by the suitable remark of the SCR. That was in the modification, that part was also omitted. So Lordship,
No, it is there, it is there.
I'll place it.
It is there.
Right? The tenure of the tenures are subject of the following, Lordship. Executive tenure be extended or curtailed, Lordship. There is no bar, Lordship, that the executive tenure should be, Lordship, 2 years or 3 years, Lordship. Even guidelines also says that, Lordship, you have the power to curtail the executive tenure, Lordship. Then my lord may kindly come to page 33, Lordship. It's an amendment in the posting policy, Lordship. Page 33, Lordship. Page 33, Lordship. So, Lordship, the amendment in posting policy of grief officers. So, my lord may kindly come to CL number 2, Lordship. The following amendments are hereby issued in the existing posting policy with the approval of the competent authority. For guidelines, para 6C, Lordship. Earlier it was, Lordship, exactly similar, Lordship. Executive 6C, Lordship. My lord may kindly compare it page 29 along with page 29, Lordship. Page 29, Lordship.
Any difference?
Same, Lordship. Nothing was there, Lordship. Same. And in respect of 6E1 earlier guidelines, now, Lordship, the amendment portion is below, Lordship. Read this, Lordship, amendment part, Lordship. Guidelines para 6C, Lordship. In page 33, Lordship. Page 33, Lordship.
Yes.
Page 33, Lordship. 6C. Taking into consideration of organizational requirement and executive tenure will generally be for 2 years for the officers of the rank of the E and above, commanding RCC, BCS, Lordship, and task force, etc., project, Lordship. Earlier it was, Lordship, 2 to 3 years, Lordship. Earlier, Lordship, 6C was, Lordship, executive tenure generally to be for 2 to 3 years, Lordship. After amendment, Lordship, it was for, Lordship, 2 years, Lordship. Then my lord may kindly come to 6C Roman 1, Lordship. Earlier Roman 1 is, Lordship, 6C1, where, Lordship, the curtailment tenure of the non-performance would be specific recommendation of the so-and-so. That is same page, Lordship, 661, 6C1, Lordship. And that was after amendment, Lordship, 6C1, Lordship. Executive tenure may be extended or curtailed based on the organizational requirements, Lordship.
So is it not the same thing?
No, Lordship. Earlier it was, Lordship, a organizational requirement, then, Lordship, other things also there. Curtailment of the tenure in case of non-performance would be on a specific recommendation of the project chief engineer C, Lordship. Here, the case is not for non-performance, it is for organizational interest, Lordship. Earlier, there should be a, Lordship, for specific recommendation is required, Lordship, in respect of the non-function of the particular officers, Lordship. That part was modified, that part was not there, Lordship, here. After modification, it was said that executive tenure may be extended or curtailed based on the organizational requirements, Lordship.
That is both in the earlier one also.
Earlier on also, but after modification, Lordship, there is that up to that part there is no sense, Lordship. Before modification, Lordship, curtailment of tenure in case of non-performance would be on the specific recommendation of the project engineer C's, duly supported with the specific instance and detail of performance counseling, supporting suitable remark in the SCR. In case of non-performance, there should be a reasons there should be a proposal there, Lordship, in earlier one, Lordship. Earlier one, Lordship. But in respect of the, Lordship,
See, page 29 and 33 are they not the same?
29 is the original one and 33 is the amended policy, Lordship.
It appears to be quite similar.
quite similar, Lordship. There is no dispute quite similar, but in respect of only that part, Lordship, curtailment part, Lordship. Curtailment part of tenure in case of non-performance, that part was deleted, Lordship, in amendment portion. Otherwise, our case is not for non-performance, Lordship. Our case is for organizational requirements, Lordship.
That is what I am saying, Your Lordship.
Our case is for.
What is that particular organization interest? There cannot be any vague or general term organization interest and they can escape the liability of explaining.
Now, Lordship.
What would be the reason?
I am not finished. Now, Lordship. Whether, Lordship, that guidelines, Lordship, as a statutory force or that petitioner can claim on the basis of guidelines that, Lordship, it should not be transferred, Lordship, before completing the, Lordship, executive tenure, Lordship. That was decided by the Honorable Apex Court time and again in various judgment, even 2024 also, Lordship. I will place, Lordship, only 3 judgment in that particular aspect, Lordship. Even, Lordship, CCS rules, there was a provisions, Lordship, that the before completion of the, Lordship, the tenure period, one cannot be, Lordship, transferred from that period. Even there was a rider was there in the section 4 that in exigencies arises, then we can transfer, Lordship. Here also, Lordship, there is no rules, but guideline is there. Guidelines also says that, Lordship, in the administrative requirement, we can transfer it, Lordship. That is the 2019, 13 SCC 788. Lordship, here I am relying paragraph 11, 12, and 13, Lordship. Before that, Lordship, paragraph 8, Lordship.
Just a minute now.
Paragraph 8, Lordship.
Yes.
Paragraph 8, 11, 12, and 13, Lordship. Paragraph 8 is the, Lordship, procedure prescribed by the CCS rules, Lordship. Section 3 and 4 are the provisions, Lordship, tenure of posting, Lordship. May I read, Lordship?
Yes, you want to read from where?
Paragraph 8, Lordship.
Read.
Tenure of posting, Lordship. For all India service officers of all groups A, B, C, state government servant or employee, the normal tenure in a post shall be the 3 years, Lordship. Provided further that when such employee belongs to the Secretariat service, such employee shall not be continued in the same post for more than 3 years and shall not be continued in the same department for more than 2 consecutive terms, tenure, Lordship. Then, Lordship, group D also, then tenure of transfer, Lordship, 4, Lordship. No government servant shall ordinarily be transferred unless he has completed his tenure of posting as provided in section 3, Lordship. The competent authority shall prepare so and so, Lordship. Then, Lordship, my Lord may kindly come to paragraph 11, 12, and 13. 11, Lordship.
Yes.
In so and so, Lordship, that the government servant is liable to be transferred to a similar post in the same cadre in a normal officer and incidence of government service, and no government servant can claim to remain in a particular place of particular post unless, of course, his appointment itself is to be a specified non-transferable post, Lordship. As the learned judge rightly observed, the norms enunciated by the government for the guidelines of its officers in the matter for regulating transfer are more in the nature of guidelines to the officer who orders transfer in the exigencies of administration than vesting of the immunity from transfer in the government servant, Lordship. Then it is not doubt to that if the power of transfer is abused, the exercise of the power is vitiated. But it is one thing to say that an order of transfer which is not made in public interest but for collateral purposes and with oblique motives is vitiated by abuse of the powers, and altogether different things to say that such an order per se made in the exigencies of service varies any condition of the service expressed or implied to the disadvantages of the government servant concerned. The petitioner who appeared in the person on place reliance as he did in High Court on the decision of the Bombay High Court, that is their lordship. Then my lord may kindly come to directly paragraph 12 lordship.
Yes.
Notwithstanding the provisions contained in section 3, which uses the expression that ordinarily the tenure of 3 years, in our opinion, in exceptional circumstances in a given case or in a case of administrative exigencies, transfer is permissible. Even lordship, the CCS rules, there is a bar. Then also Honorable Apex Court says that we can lordship. And no absolute bar on transfer is created by virtue of the provision contained in section 3, read with section 4. In the fiction circumstances of the case, also consider the past record so and so, so and so, so and so. Even lordship, if there is a statutory prescription is there, lordship, regarding the tenure, then also lordship, we can lordship transfer that particular person's lordship. There is no bar, lordship. Regarding guideline, lordship, one of the judgment I will place SL Abbas lordship.
See, we'll examine all these aspects. You obtain instructions.
Otherwise, lordship, here, lordship, the transfer order is very specific, lordship. On the basis of lordship, the organizational requirement, we have transferred it, lordship. This is that will be our instruction, lordship. Already I have telephonically contacted the concerned persons, lordship. He says that on the basis of organizational interest, lordship.
How do you substantiate that? Organizational.
Lordship, when transfer order is issued, as per the law laid down by Honorable Apex Court, what is his duty, lordship? He has not represented before the authority, lordship.
I am represented on Monday.
He is not represented before the authority, lordship.
Represented on Monday, I could not annex that writ petition with the writ
He have to, lordship.
because that is basically pending. I could not because of paucity of time. This order was issued on Friday.
You submitted to whom? Representation.
This representation to the chief engineer of the project.
Who is the authority to consider such kind of?
Basically, not chief engineer, the respond number 2. Respond number 2.
Who is respond number 2?
The DGPM, who has issued this order.
His station.
Lordship, I like to SL section as judgment, lordship. My lord may kindly paragraph 6, lordship. SC section as judgment, lordship. What is the law laid down by the Honorable Apex Court? What is the dictum of the Honorable Apex Court, lordship? 6, lordship. Paragraph 6, lordship. We have perused the records with the help of the learned counsel and heard the learned counsel very patiently. We find that no case for our interference whatsoever has been made out. In the first place, a government servant cannot disobey the transfer order by not reporting at the place of posting, then go to a court to ventilate his grievances. It is the duty to first report for work where he is transferred and make a representation as to what may be his personal problem, lordship. This tendency of not reporting to a place of posting and indulging in litigation needs to be curbed, lordship. Apart therefrom, if the appellant really had some genuine difficulty in reporting from work Tezpur, he would have reported for duty at Amritsar where he was so posted. We too decline to believe the story of his remaining sick. Assuming there has been some sickness, we are not satisfied that it prevented him from joining the duty either in Tezpur or Amritsar. The medical certificate issued by so and so, we too are of the opinion that appellant is guilty of the misconduct or unauthorizedly remaining absent from the duty. At first, lordship, he has to report the place of posting, lordship. Then he has to represent it, lordship. This is the legal principle and lordship dictum of the Honorable Apex Court, lordship. At first, he have to join, then he have to ventilate his grievance, lordship, by way of representation, lordship. And regarding transfer policy, recent Honorable Supreme Court judgment there, I am relying that judgment, lordship.
This is motion hearing.
No, your lordship.
Otherwise, it's a case of administrative exigencies, lordship. Project requirement is there, lordship.
If I may just rely on just one line of the judgment which my learned friend has placed before your lordship. This judgment.
I have not finished, lordship. I have not finished. Just I'm relying another judgment.
This we will see later on, your lordship. This your lordship.
If lordship simply issue notice, lordship.
That's a settled law.
If lordship issues a simple notice, I have no objection, lordship. First, he have to join the particular place of posting.
No.
You submit. Please hurry up. See, we are spending so much time on this issue.
Lordship, I rely paragraph 23 to 27 in this judgment, lordship. 23 to 27, lordship. Paragraph 23 to 27.
This is regarding what?
Regarding transfer policy, lordship.
Policy you have
Your Lordship,
already
I'm not on
shown.
that particular issue, Your Lordship. I'm on the issue of frequent
Like,
transfer.
Freq-
Frequent transfer without
He is-
reason
he is-
is being curtailed by
There
the Honorable
there is a
Supreme Court.
reason, Lordship.
I'm actually
There-
relying
there-
on the judgment of the Honorable
There,
Supreme Court.
there is
that
a
laid
reason,
down
Lordship.
as
There is a
denied
reason,
upon
Lordship.
my learned friend,
There is a
Lordship.
reason, Lordship. Page 27, Lordship. Reason is there, Lordship. Page 27, reason is there, Lordship. He basically says on relying the guidelines issued by the authority, there should not be a curtailment, Lordship. Basically relying that, Lordship. So what Honorable Supreme Court says that it is explained from paragraph 20 to 27, Lordship. Internal page 26, Lordship. Paragraph 24, Lordship. Lordship, got it?
Yes.
First and foremost, transfer is an all India service in an incident of service. Whether and if so, where an employee should be posted are the matters which are governed by the exigencies of service. An employee has no fundamental right or to, for that matter, a vested right to claim a transfer or posting of their choice, Lordship. Secondly, Lordship, executive instruction and administrative direction concerning transfer and posting do not confer an indivisible right to the claim of transfer or posting. Individual convenience of a persons who are employed in the service is subject to the overreaching needs of the administration, Lordship. Then 26, Lordship, and 27, Lordship. And one of the recent judgment, division bench judgment of our High Court, Lordship. It was delivered on, Lordship, 2/12. This month, it was delivered, Lordship. Here I am relying, Lordship, paragraph 6, 8, 16, the facts, 17, Lordship, facts, and Lordship 2, 22 to 23 and 29, Lordship. So, Lordship, may kindly mark the paragraphs, Lordship.
Paragraph 6, what do you say?
Paragraph 6, 8, and 16 regarding the facts of the case, Lordship. And 17 also, Lordship.
Facts of the case.
Regarding
What is the ratio? Lead down.
Ratio is, Lordship, it starts from page 20, Lordship, paragraph 20, Lordship. Paragraph 20, Lordship.
What else?
The Honorable Supreme Court in the case of so and so,
No, Mr. Bush,
paragraph
see,
22, Lordship.
don't read everything now. You just tell me the paragraphs. 20. 8, 6, 8, 16, then 20.
Lordship, 20. 20, Lordship, 21, 22, and 20, 21 and 22, the recent judgment of the Honorable Apex Court was discussed, Lordship. Then, Lordship, paragraph 23. After discussing the dictum given by the Honorable Apex Court, the Honorable Court says that, Lordship, in view of the above, we are of the view that learned tribunal has erred in holding that transfer policy that so and so is a statutory nature. Apart from that, after carefully going through the transfer policy, we do not find that there is any provisions which prohibits the railway to transferring the employee from one zone to another and zone before completing the minimum tenure at a place of posting on which he was transferred within the same zone from other place. Here also, Lordship, frequent transfer is there. That part, Lordship, that's why facts part I am indicating paragraph 6, 8, paragraph 6, 8, 16, and 17, Lordship.
Okay.
Lordship, my case is a case of frequent transfer. I'm relying on the judgment which has been relied by my learned friend in EP Roepa. EP Roepa, if your Lordship takes up that judgment of Dr. Nagarao Shivaji Chavan, 2019, 13 SEC 780. My learned friend has relied on this particular judgment.
No, what is the judgment?
That judgment where, Lordship, statute, there is a statute provision is there. I have not completed. I have not completed.
If he has not completed,
I have
then-
not completed. He is
See, we'll hear the matter tomorrow. Since both of you are giving me all these judgments, we cannot pass any order like
Lordship,
that.
fix it tomorrow. I can.
Lordship, just that his reliever.
I have
will
to.
join me
I have
tomorrow.
to place my case, Lordship. I have to place my
See,
case.
this is a motion only.
Yes, your Lordship.
We are not hearing the matter today.
If Lordship issued
That is
notice,
what-
I have no objection, Lordship.
That is what your Lordship.
Lordship.
I'm
If
just
Lordship,
stating that.
if Lordship hearing on the regarding stay order, then Lordship to hear it.
Your Lordship may kindly just
list
take into
again tomorrow.
consideration one particular fact, Your Lordship, this is a case of frequent transfer.
You have given your judgments. I'll read that and we'll see tomorrow what is to be done.
Your Lordship, my reliever will come by tomorrow, Your Lordship. If Your
What to
Lordship
do?
may take it up at 10:30 tomorrow as a first item, Your Lordship.
I don't know what it's.
Regarding that part also, reliever part also, latest judgment of the Supreme Court says
Your
that.
Lordship, everything has got a
Look,
counter. I
Supreme Court
cannot
has said that.
say
Lord.
anything, Your
Supreme
Lordship.
Court has said that. I will place that particular paragraph.
If it
also.
is, if
What
this is not
Supreme
a
Court
final
says.
yet, Your Lordship, this is the motion stage. And
Motion
whatever
stage-
records will reveal, Your
Motion
Lordship,
stage
what is
is
the
already
reason?
directed.
Enough, Mr. Goswami.
Lordship.
What is the reason?
Enough. We'll listen tomorrow, not today. The other matters will come up on the dates to be, as may be required, be fixed.
Lordship, item 40, Lordship, 40. Can it be taken up day after tomorrow, Lordship?
I don't understand that.
Day after tomorrow to Saturday. Oh, Friday. Friday.
May it please your Lordship.
Item 40, Lordship, 40. Can it be taken up day after tomorrow, Lordship? I was in suspension, Lordship, since Lordship, appeal, Lordship, without any. On 16, Lordship. On 16, 40.
May it please your Lordship.
On 16, Lordship, item 40.
May it please your Lordship. Item number 22, my lord. There is a interim order, interim order is there. Item 22.
That's why I'm saying whatever matters left today,
My lord.
just inform the court master.
My lord.
Then if interim order is there, inform him. We'll pass necessary orders, okay?
My lord, the opposite
We'll
side.
get
is
a
an-
date.
Yes, my lord. But the opposite side is an outstation council.
Mm.
So we pray for a fixed date for the item 22.
Exactly. So
On February.
the date which is convenient to you, please make a mention to it.
Much obliged.
In item 30, the matter, part of the pension matter, Lordship, it is maybe come on next week.
Much obliged, my lord.
I've already said what happened.
30, obliged.